अभी तक तो हम नहीं देखे थे डायरेक्टली इस पर कोई जजमेंट.
Under heading for admission, item 3, WPC 5082 of 2019.
Petitioner?
Last occasion,
Why have you not filed your contract?
the counter not received it. Today itself I have talked to the concerned authority. They say for some more time.
How much time do you need?
2 weeks by way of last.
Are you for the petition? The learned counsel for the parties are present. Are you representing railways?
Railway.
The learned counsel for the respondents, Mr. Ravi Prakash, prays for and is granted time till 13th of December or maybe 17th of December by way of last indulgence to file the contract in this case.
Three times the I have.
Yes. The contract, since the contract affidavit has not been filed in spite of repeated orders of this court, let a copy of this order be communicated to the Secretary, Ministry of Railways. Within bracket respond number 1. Mail ID? Mail ID?
Net से लेना पड़ेगा.
नेट से लेना पड़ेगा.
तो क्या हम लोग
This is too much. By the office of this court to ensure compliance.
deeply obliged.
हाँ. Post this case on 19th of December. अपना मेल आईडी सबका लेकर रखा करें, क्योंकि ऑर्डर में ही लिखाएंगे मेल.
लिस्ट का है.
कोई बात नहीं, सेक्रेटरी को जाएगा तो सब अपने, और ये ऑर्डर आप अपनी तरफ से भी कम्युनिकेट करें. नेट से ऑर्डर लेकर सब कुछ जो आपको करना है करें.
Item 4, WPC 1265 of 2020.
Esther Prakash not here. Today his brother's marriage on Dumka. He has not.
The case will not be
Next
adjourned.
week.
No. Why next week? It was listed today at his instance.
मैरिज है वो यहाँ दुमका, उसके भाई की वो दुमका चली.
परसों शादी नहीं थी क्या?
उसको पता था, उधर गया था.
परसों पता थी ना कि आज शादी है घर में, कि नहीं पता था?
नहीं, उसको पता था.
तो फिर आज के लिए क्यों रखवाएं किसको? कॉस्ट के साथ एडजर्न करेंगे, ऐसे नहीं एडजर्न करेंगे. बोलिए, उनको बोलिए ऑनलाइन ज्वाइन करने. छोटा सा मैटर है. ऑलरेडी यहाँ पर काउंटर एफिडेविट आया हुआ है कि NHAI अथॉरिटी के पास जाना है. दे हैव एन ऑल्टरनेटिव रेमेडी. या फिर कॉस्ट के साथ एडजर्नमेंट लीजिए, बिना कॉस्ट का एडजर्न नहीं करेंगे. आइए पूछकर समझ कर आइए, ठीक है? पास ओवर कर रहे 1 बजे आइए.
Item 5, WPC 3558 of 2020.
Where is the private respondent? Are you for the private respondent?
No, I'm for the state.
Where is the private respondent? Mr. Rashidi was.
Mr. Rasidi.
Where is he? Come at 12:30.
Item 6, WPC 3662 of 2020.
The report has come.
Report has come.
Report says primarily, generally there is no slurry.
No.
What is the relief claimed? They are not
They-
appearing.
No, they are not appearing, and there is one intervention application also
Yes.
by one Shravan Singh.
And I think Mrs. Ritu Kumar does not hold the wakalatnama.
No, she might have been engaged.
He might have been engaged, maybe that they are not engaging her anymore.
Anymore, maybe.
Ah.
The
He
relief
did not
is also
appear
direction
yesterday,
upon the
nobody even prayed
respondents.
for adjournment yesterday.
The relief is, Your Lordships. It is not a direction upon the respondents to remove the slurry if they have.
That's right.
This is a direction upon the respondents to allow the petitioner to remove. This is the mischief they want, Your Lordships.
Allow the petitioner.
Yes.
Since there is you have no objection in whatever manner they want to use the land.
But we have no objection regarding use of land.
Yes.
But on the pretext of removing slurry or otherwise, they cannot illegally mine or anything that is a national. Therefore, Lordship, once there is a report that there is no slurry, no relief can be granted.
Yes, madam. Are you there in this case?
Yes, Your Honor. Yesterday, actually, I thought IA has been filed on by.
We will not bother about IU. IU, there is nobody to press the IU, so it has to be dismissed. You are the intervener. What do you want?
उसमें रीड का कॉपी नहीं मिला।
उससे कोई मतलब नहीं है ना. आप इंटरवेनर फाइल किए तो पता करके फाइल किए होंगे क्या किसका रीड है. क्या है आप? Who are you?
He is the person who wants to remove the slurry. Says that I have been authorized by the petitioners to remove the slurry.
Even the annexures, Your Lordship, even otherwise, Your Lordship.
You see, we have a report that there is no slurry.
Now, as far as that report is concerned, Your Lordship, if Your Lordship sees the photograph at page 14,
Photograph we will not.
जूता में पूरा slurry लगा हुआ है.
क्या चीज? बताइए.
Photo अगर देखा जाएगा, तो that only 2 photographs. In the second photograph, in the shoes of the person, there is lot of slurry. It is.
यहाँ से हम लोग डिसाइड करेंगे कि उसके जूता में लगा हुआ है तो वहाँ स्लरी है.
नहीं, my contention is there were other reports.
You see, the point is you can use the land in whatever manner you want to.
ठीक है.
The moment you remove, they will have a right to see what are you
No,
doing.
unless and until I remove that mud,
Do not.
how can I do the paddy
खेती
work?
तो चल रहा है आपका. पूरा फोटो है खेती का.
मुझे वही तो हम बोल रहे हैं कि खेती नहीं चल रहा, वो जंगल है, खेती नहीं है, जंगल है. हमको खेती भी करने के लिए हमको वो साफ तो कराना होगा.
ठीक है, साफ कराना होगा ना.
हाँ.
तो they will have a right to take it away. You will not have a right to sell it. You see, आपको साफ कराना है, मिट्टी निकाल के बाहर फेंकना है, बड़े आराम से फेंकना. But the moment you take out anything out of the land, CCL will have a right to use it. Because there is a likelihood that there could be underground mining or whatever.
हम हुजूर ये ऑर्डर पास
आपके
किया
लिए
जा
तो
सकता
वेस्ट ही
है
है ना. आपके लिए तो वेस्ट ही है. आपको हटाना है,
नहीं,
साफ
हुजूर,
करना
हमको
है.
हटाना, हम हटा के कहाँ फेंकेंगे, कहाँ
नहीं, वो क्या चिंता-
हम जैसे हटाएंगे ये पहुंच जाएंगे. हम अपना खेती ही नहीं करेंगे क्योंकि
नहीं,
इसको हम हटाएंगे.
आप
ठीक है.
हटाएंगे.
हम हटाएंगे.
हाँ, बेचिएगा मत.
नहीं,
Not for sale. If they feel that it is slurry, they will take it.
नहीं, ये
आप-
पाइप
लोग
करके हमको
देखेंगे।
इन्फॉर्म कर दे, हम
हाँ।
उठा लेंगे अगर स्लरी है तो
उठा
we'll
लेंगे।
examine it और
We will
पढ़ेंगे।
examine it.
हुजूर, now the report shows that there is no slurry. ठीक है, या तो रिपोर्ट माने या तो नहीं माने. अगर रिपोर्ट के हिसाब से स्लरी नहीं है, ठीक है, तो वहाँ जो है वो मेरा है. अगर
जो
स्लरी है
है
तब ना सीसीएल
मड है ना. You say slurry है, वो
हाँ।
बोलते हैं नहीं है.
नहीं है.
We do not know what is there.
So how can your lordship say
Just a
pass an
moment.
order to that extent कि if I remove anything, I will inform CCL and CCL will come and take it.
Lordship,
There is no
Point
slurry.
is-
Admittedly, well, CCL says there is no slurry. I agree with the report.
Lordship,
there
may I
is no
suggest
slurry.
one thing, they should not, they can use the land in the manner they want.
They want to.
But at any point of time, if they want to remove any mineral, not coal or slurry, they will have to comply with the provisions of MDRR, otherwise they will be liable for the consequences.
The provision of law, the moment you start removing anything from the
There is
land,
no slurry, your lordship.
Any mineral.
anything,
Anything कैसे हो सकता? हम कोयला नहीं remove करेंगे.
पत्थर भी नहीं निकल सकते।
आप पत्थर भी नहीं निकाल सकते ना वहाँ से. Because you see, if there is any removal from the land of anything from the land, right? Then under such circumstances, if there is a provision under MMRD Act, it has to be compliant. सिंपल प्रोविजन ऑफ लॉ कंप्लायंस से आपको क्या प्रॉब्लम है?
हमको तो समझ में नहीं आ रहा, वो जो मेरा जमीन है
आप
हम
यूज
अपनी
करिए ना,
जमीन
आपको
में
जैसे करना है
जैसे जो
यू
करना
कैन
चाहिए।
यूज इट इन वॉट एवर मैनर यू वांट।
Yes.
यस दैट्स इट।
हाँ, उसको कर दिया जाए। I can
उसी को
use
कर
it
देते
anywhere.
हैं। You can use your land in whatever manner, but in case there is any removal, the provision of law will come into
No,
play.
your
In
lordship
accordance
is
with
taking-
law,
If your lordship is
in
taking,
accordance with law, certainly.
if your lordship is taking this report into consideration, I'm sure that your lordship will write that there is no slurry as per the
You
report.
see, we will not give a finding in 226 report slurry है नहीं है क्या है
ये तो
because
रिपोर्ट का तो कोई मतलब ही नहीं है, तब तो है कि भाई हम आप बोले कि फोटो नहीं देखना है क्योंकि जूता में नहीं देखें, जूता
हमको
हम
तो
कैसे
यही नहीं
देखेंगे?
समझ आ रहा है कि यहाँ से हम लोग क्या ही करा सकते हैं। अगर मान लीजिए यू जस्ट हैव अ लुक एट इट, अर्लियर देयर वाज अ रिट पिटीशन कि कॉम्पनसेशन मिलना चाहिए,
हाँ,
राइट? डैमेजेस चाहिए, कॉम्पनसेशन चाहिए, आप सिविल कोर्ट में जाइए। हाई कोर्ट से यहाँ से क्या ही क्वांटिफिकेशन हो सकता है कॉम्पनसेशन। दूसरा बात, कॉम्पनसेशन क्या चीज़ का होगा? अगर मान लीजिए कुछ आप डैमेज सफर करेंगे तभी ना कॉम्पनसेशन होगा, उसके बिना तो कॉम्पनसेशन नहीं हो
क्योंकि
सकता।
हम इसलिए सेकंड रेट फाइल किए बिकॉज ऑफ
Therefore-
दिस मड और स्लरी
Yes.
आई कैन नॉट डू माय एग्रीकल्चर।
Yes.
So unless and I remove this slurry, so I only wanted the mud waste accumulated on my field, I should be allowed to remove.
You want to remove it?
Yes.
Fair enough, right?
अब
The
यहाँ
moment
पे हम
just a
CCL को
moment.
खबर करेंगे,
नहीं खबर
CCL
नहीं
आएगा
करेंगे।
तो कहाँ ना मेरा प्रेयर है ना इनका ये।
खबर करने का कोई बात नहीं है। बात ये है कि
यही तो बोले कि कुछ निकालेंगे तो फिर डंप करेंगे, फिर
नहीं,
हम
नहीं,
उनको
नहीं,
खबर
कुछ-
करेंगे तब ये आएंगे।
नहीं नहीं कुछ मत कीजिए.
कहाँ कुछ
हम
बोला?
अपना सीधा
If
सीधा है कि
I want to
आप
do anything over my house also, Lordship, I have a right over the surface. Underneath the
आपको
surface.
surface right तो है
Yes.
ही। If there is anything which you want to remove from the land, right? And if that has to be
This
done.
is the issue, Your Lordship. If I want to remove anything from my land,
Yes.
कल को CCL आ जाएगा कि आप धान कैसे कट रहे हैं? I'm removing
No, no, anything, any mineral from the land.
Any
ठीक
mineral
है,
from the
अब
land ना?
वो जो mud है वहाँ,
You see, I can just simply observe that if there is any removal from the land in connection with surface or whatever, underground or whatever it is, then under such circumstances,
सरफेस नहीं बोला जाए, अंडरग्राउंड बोला जाए, उसके लिए हम एग्री करते हैं, लेकिन
Underground
सरफेस से
तो-
कैसे नहीं हटाएंगे वो जो, जब तक ये मड हम नहीं हटाएंगे,
अगर
ठीक है,
आपको
जब तक ये मड नहीं हटाएंगे तब तक हम पैडी नहीं लगा सकते।
तो आप जब आप मड हटाएंगे ना, तो आप बस हटा के छोड़ दीजिएगा। बाकी
कहाँ
जो
छोड़ेंगे
जो-
हम?
ये इन लोगों को जरूरत होगा तो अपना करेंगे वो लोग।
जो खेत है, ठीक है, उसको इमेजिन करते हैं खेत है, उसको उठा के हम कार बगल वाले के खेत में डाल देंगे। CCL को खबर करेंगे हम हटा दिए हैं, हम बगल वाला खेत वाला वेट करेगा, अच्छा आ रहा है CCL, क्योंकि हमको खेती करना है। ऐसे थोड़ी होता है जो।
आपका क्या प्रेयर है? आपका प्रेयर के बियॉन्ड तो नहीं जाएंगे
नहीं,
ना?
बिल्कुल नहीं जाना।
तो चलिए पढ़िए अपना प्रेयर पढ़िए।
This application is directed for issuance of an appropriate writ commanding upon the respondents to allow the petitioners to remove mud/waste from their righty lands forthwith to enable the petitioners to get the land in question fertile after removing mud, waste, etc., which was accumulated due to overflow of the washery waste of CCL.
Now who is stopping you from removal?
अभी तो बोली
नहीं आप अपना रिट से बताइए ना, who is stopping you? That what was the occasion for you to come to this writ petition? What was the occasion? Who stopped you from removal? Because you are seeking a mandamus. You must have approached somebody. Somebody must have refused you. Where is this? Where is that?
हम पढ़ देते हैं।
हम बताइए what was the cause of action? बताइए what was the cause of action?
Page 5, para 8. That since the slurry mixed with mud was overflown into the land of the petitioner, the crop standing on the aforesaid land is completely ruined, and compensation has been paid to the landlord such and such by post facto sanction such and such. The second time also on the ground of overflow of the waste products from the washery, the respondents have been paid. So ये तो that the 11 landowners including made an application to the local authorities of Rajrappa project requesting them to pay for the overflown slurry and mud into
Para number कौन सा?
para 10
Para for the second time.
second time
पढ़िए
para
आधा सेंटेंस मत पढ़िए, पूरा पढ़िए।
हाँ, पूरा पढ़िए। para 9.
हाँ,
That the petitioner state that for the second time also on the ground of overflow of the waste products from the wash bin, the respondents have paid compensation in the year 1997 to the tune of rupees 26 lakhs 152.50 by sanction order dated 2/7/97. That the petitioners state that 11 landowners, including the petitioners, made an application to the local authorities of Rajratpa project requesting them to pay compensation for the overflow of slurry and mud into their land. The petitioner also submitted the relevant papers relating to land with Malgujari receipts, Hathiyan, etc. and the map of the site wherein the waste of this washery was accumulated. The petitioners also state that due to overflow of the slurry, mud and other waste products, their land got damaged and were not cultivable. That the petitioners state that the Deputy CSM Rajrappa project has forwarded the application of the petitioners to respondent number 2. That since the petitioners state that the respondents that after made verification of the land in question and it was recommended that 9,295 metric ton of overflow slurry can be offered for removal to the concerned persons in the lots of 1,000 metric ton against full advance payment at the price as per the declaration date of Rajrappa project, and the same was sent to respondent number 5 for his approval and for necessary action. That the petitioner states that after physical verification and demarcation of the land on which the waste product of the washery was accumulated, the respondents have taken a decision to remove the slurry and waste products from the Raiti land of the petitioner and has entrusted them to remove the waste products from the land of the Raiats, and for the said purpose certain amount has also been to be paid to the person authorized by the Raiats. The petitioner states that in the year 1999, in view of the work order issued in favor of the Raiat by the CCL authorities of Rajrappa, the petitioners had removed the entire waste product of the washery from the Raiti land through their authorized representative, Shravan Singh, on whose behalf IA has been
no,
filed.
that's right. You say that you have already removed it.
In the year, every
99.
time, 99. So every time
उसके
it
बाद
comes on my
और ये तो 99 का कहानी
हाँ,
हुआ,
उसके
उसके बाद
आगे
लेटेस्ट
बताते
कहानी
हैं
में
ना।
आई।
उसका देखिए para 19 में on 10/6/2013 the senior supervisor C has given his report wherein he has stated that the land where slurry accumulated is uneven and some part are diluted, and as such it is not possible to determine the actual height of the slurry. The senior supervisor as such observed that if average height of slurry accumulated for the private land of Buchubag D village is taken as 0.5 meter, the quantity of slurry is 11 acres of land comes to be 22,718 metric ton. The petitioner said that they have constituted a committee for looking into the matter. The respondent number 7 has proposed for declaration of grade of slurry which has been found in the land in question. The said authorities also directed the concerned authorities for lifting the materials like overflow slurry from the land of the petitioners. The local authorities of Rajrappa project were also directed to take all steps to stop the overflow of slurry to the land outside of CCL area. That a petitioner state that although the decision have been taken by the respondents for removing of the lifting of slurry and waste products from the land of the petitioner, that decision has not been implemented and delivered till date. The waste products accumulated in the land of the petitioner have not been removed. The petitioner represented the Land and Revenue Department of CCL for redressal of the demands. उसका 2015 में हुआ, 16 में हुआ, चलते जा रहा, वहाँ पे तो अब स्लरी है ही नहीं, जो चीज है उसको हम कहाँ रखेंगे, हम हटाएंगे खेती करने के लिए, तो where will I put those waste things? So either they should ensure that slurry does not come to on my land, or I may be permitted to remove it.
Mr. Das,
Yes.
in para 36 they have said that they had moved this court earlier in WPC number 1357,
Yes.
either to pay compensation or to remove this.
Yes.
That writ petition was disposed.
Disposed of.
Then ultimately nothing happened thereafter.
No, thereafter inspection was made. It was found that there is no slurry, and the state government authorities also said, Your Lordships, that no, their farming is going on over the land. So we can turn to page 52 first. First, Lordship, we got the nature of land verified. Yes, Lordship, can you see?
The point is, Mr. Das, we do
Yes.
not know what is the present status of the land. Photographs and all cannot really justify whether there is slurry or there is no slurry.
And whether they are the owner of the land.
And
also.
just a moment. And we can just ask you to conduct a fresh inspection. If you want to take anything from the land, you take it. If you want to take anything from the land, you take it.
We are not, I just tell you, one instruction is, there is no slurry, which is sellable. But Your Lordship, the entire area is a coal bearing area.
That's right.
If a person digs
In anticipation, we cannot say.
No, not in anticipation.
Yes.
What I said is nobody can be prejudiced. This order can be made applicable for my house also, for this High Court building also.
Yes.
Lordship, the High Court building, the High Court has the right over the surface of the land. Anything beneath the surface is a national property.
That's right.
So therefore, if they want to remove any mineral,
That should be above the surface, isn't it?
any mineral from any place, if there is a hillock also in above the surface, and if I want to break it, I have to take the permission from the district mining officer.
That's
For removal of mineral, they will follow the law of the land. Otherwise, we have no objection. We say there is no slurry. And there is an inspection report also certifying it. Our inspection report, kindly see our counter affidavit.
according to you, there is no slurry on the spot.
There is no slurry. Lordship, I kindly see. Lordship, in the
Then,
coal
then,
bearing areas,
then that should be sufficient to say that they are free to use the land
in the
accordance
manner
with
they
law.
want,
In accordance with law, whatever be the
yes,
law.
if they want to remove any mineral, they have to follow the law.
कहाँ से जब ये
No,
कहीं
whatever.
नहीं मिनरल नहीं है तो
Yes.
कहाँ से
अगर मान
मिनरल
लीजिए वहाँ से कुछ भी रिमूव करना है मिस्टर दास,
हाँ.
without saying of this court, they have to follow the law.
नहीं नहीं
Yes,
they
yes.
have to acquire the
No,
land.
this
if they
order
want
should
them.
not, our only anxiety is, this order should not be misused by them by, yes.
No,
Lordship,
so
kindly see.
Can we quote your statement
Yes,
that according to you, there is
Yes.
no slurry on the land?
there is no slurry in the land. We are.
And they are free to use the land in
the
accordance
manner-
with law. In
हाँ,
accordance with
if
law.
if they are the owner of the land, because state government report says they are not the owner of the land.
हथियार
That also we
लगाए
have
हैं
brought
सब
on record.
लगाए हैं
Yes.
तो बोल देना चाहिए.
Lordship, may kindly see the report of the state government also. Also, I'll show one by one, 3 photos.
That should be
Lordship.
sufficient, Mr. Das.
Yes.
This much of observation should be sufficient that they are
Yes,
free
yes,
to
Lordship.
use the land in
Yes,
accordance
Lordship,
with
whatever is
law.
our anxiety, I have Lordship
That's
mentioned.
it.
Lordship, our anxiety is in the pretext of the or taking advantage of this other, they should not. And so far as the
That should be
intervener is
sufficient.
concerned,
You can use the law in accordance with law, whatever
And
it
if
is.
they want to do anything, they have to
We
acquire
will
the
not
land.
make
They
any
cannot say
observation.
कि
You can use the law in accordance with law. इसके लिए कोई
Land in
declaration का
accordance
जरूरत
with-
ही नहीं है.
हाँ, ठीक है.
इसके लिए कोई observation का जरूरत नहीं है. The law is certainly there with you. If it is your land, you are certainly free to use it in accordance with law.
And if they want to do something on my land, they have to acquire it. ये
Yes,
नहीं है कि
yes.
बिना acquisition का they cannot take.
नहीं, नहीं, हम लोग
WPC
अपना
number
inspection करेंगे.
WPC number 3662 of 2020. This writ petition has been filed for the following relief. Pursuant to an order passed by this court dated 23rd of September 2024. A physical verification report has been received. The observation of the committee report and the conclusion is as under. Para number 3 यहाँ से कोट करेंगे ना, पेज नंबर 3 से ऐसे डॉट डॉट बना हुआ है, लास्ट तक कोट करेंगे, फ्लैग 3. However, the learned counsel for the petitioner has submitted that as per the prayer made in the petition, there is the mud waste etc. has been accumulated due to overflow of washery waste of CCL. The learned counsel appearing on behalf of the respondent CCL has submitted that as per their report, there is no slurry on the land and the property do not even belong to the petitioners. To this, the counsel for the petitioner submit that they have right, title, interest and possession over the property and CCL cannot question their title over the land, and if they want to use the land of the petitioners, it has to be done only in accordance with law. After hearing the learned counsel for the parties, this court is of the considered view that if one or the other portion of the land belongs to the petitioners and they have right, title, interest, possession, सब slash करके डालेंगे, then the use of land has to be in accordance with law. And both the parties are bound to follow the law. This petition is disposed of with the aforesaid observation. That should be sufficient, final?
Yes, sir. Obliged.
ये report है, quote करेंगे.
Item 7, WPL 5791 of 2020.
Finally, there is actually a family emergency in the family of senior learned counsel. His mother is on ventilator. So, bring this case to list after 3 weeks.
WPC number, WPL number 5791 of 2020. Mr. नाम बताइए अपना.
My lady Roshan Kumar Singh.
Mr. Roshan Kumar Singh, advocate, submits that on account of personal difficulty in the family, Mr. Mahesh Tiwari is not coming to the court. He will not be available for 3 weeks.
Most probably.
And he will not be available for 3 weeks. He submits that the matter be posted after 3 weeks. closed this case on 18th of December in the supplementary cause list.
Item 8, CMP 981 of 2024.
This case was refused for default by an excess of 1
CMP number 981 of 2024. Counsel for the parties are present. This petition has been filed for restoration of WPS number 6629 of 2023, which stood dismissed on account of non-removal of defect in terms of order dated 14/5/2024. The learned counsel submits that due to illness of the counsel, he could not attend the case, and ultimately the case has been dismissed. He submits that the writ petition be restored. The counsel for the respondents.
Statement James.
The learned counsel for the respondents have any objection? No serious objection to the prayer for restoration. Considering the aforesaid submissions, the time for removal of defect in WPS number 6629 of 2023, as granted by order dated 14th of May 2024, is extended till 6th of December. If the defects are removed within time, let the writ petition be placed before appropriate bench as per the law. The order continues to be painful. The order continues to be painful. 6 तारीख को नहीं रिमूव करेंगे, फिर से डिसमिस पर डिफॉल्ट हो जाएगा। बताइए कब तक टाइम चाहिए आपको? 13 तारीख दे दें, 20 तारीख दे दें, कब तक दे दें?
6629 18 तारीख को बैच केसेस के साथ लगा हुआ है।
वो हम नहीं जानते। आप 6 तारीख तक डिफेक्ट रिमूव कर दीजिए, इट विल बी लिस्टेड एज पर रोस्टर, फिर आप मेंशन कर दीजिए। अदरवाइज 6 तारीख को फिर डीएफडी हो जाएगा।
From the daily list under heading for final disposal, item 5, WPC 585 of 2019.
Yes, petitioner.
They've asked a portion of the house rent allowance ordinance that was passed for enhancement of rent. They are the tenants. I was the previous owner. I've sold my property now
It has already been
in a connected
Vacated?
matter.
it has already been vacated as per the report.
Yes. The subsequent purchasers, the after
दुकान
that
खाली हो चुका है,
खाली हो
वहाँ
चुका
एक
है।
द्वितीय पक्ष के निर्माण कार्य किया जा रहा है।
Yes, किया जा रहा है।
क्या ही बचा है इसमें?
Only dues are left, Alicia. I am the previous owner. They have not paid dues of the rents since 2013. Close to 7,90,000 is my dues that still subsists as on date. Two lakh was deposited subject to the court's direction, but thereafter nothing has been paid to me.
And where is the petitioner? counsel for the petitioner is absent. As per report dated 7th of September 2024. Submitted by additional collector to the deputy commissioner, district magistrate, BDD. The shop has already been vacated.
The new persons who are the owners of the property.
I'm actually not able to respond number 6 and 7. I'm the
Current state.
What is to be done in this case? Tell us what is to be done in this case. Petitioner is not appearing. You are the new person, you owner of the property.
I'm at present the owner of the property. And they have vacated in the month of April. Therefore, I have filed one petition for direction to make the payment as fixed by the House Controller, confirmed by the Commissioner, Deputy Commissioner and Commissioner, till March 2024.
It
And
was not your
earlier-
petition which was allowed. Was that your petition which was allowed? How an order can be passed by this court to give the rent to the successor in interest?
He was in possession as a tenant from the erstwhile owner. And
Who will get the tenant? The original owner or the successor?
original owner will get till the date he possesses the property as a owner.
Automatic तो नहीं होगा ना.
And thereafter I.
Automatic ऐसा नहीं हो सकता. The purchaser of the property has also appeared before this court. कल कर देते हैं, नहीं आएंगे तो डिसमिस करते हैं. We'll simply sit and dismiss it. They are not interested. We'll give them one opportunity.
Well,
Since the
tomorrow
petitioner is absent,
I am tomorrow I am not here.
they are.
No, my lord, I will be back on third, let it be on
Since the petitioner is absent, in order to give one more opportunity by way of last indulgence, pose this case on 4th of December 2024 in the supplementary
fourth.
causes.
Petition.
4th of December. Supplementary causes.
I
Item 7 WPC 670 2019.
Last petition also directed the state to file counter efforts.
It is ready.
State counter effort is also academic.
Sorry?
It is an academic counter effort. Lots of fallacy there. They have not answered the question which I have raised. The question is not whether the certificate of holder can be a certificate officer. That is the question which is involved in this case.
Kindly to the last order, Your Worship has passed. The learned counsel for the petition submit the district transport officer Devgar is the certificate holder and is also the certificate officer in the present case. The learned counsel submits in the case any objection is filed under section 9 of the Bihar and Odisha Public Demand Recovery Act. Then under such circumstances the certificate holder would decide the objection also. He has submitted that the certificate holder cannot be a judge in his own case. He further submitted that a specific stand has been taken in this regard in paragraph 13 of the report. The learned counsel for the state is directed to examine this aspect of the matter and advance his argument on the next date to file a specific affidavit. To that effect, Your Worship, we have filed the affidavit and in para 8 and para 9 is relevant. Kindly follow notes in our affidavit para 8 and para 9.
Is that it?
Para 8 University Status submitted, however, in this case, as informed by the DTO, therefore letter number so and so, district transport officer and other officer from serial number 1 to 14 were appointed to be the certificate officer with the sanction of the commissioner by letter number so and so. This is the notification issued. And how this is issued, you issue? Para 9. Mention that the appointment of the certificate officer at district level is completely the matter related to the district, and the Department of Transport is not related to this. It is completely the authority of the district collector to appoint the certificate officer of pertaining the sanction of the divisional commission. So affidavit to this aspect is required from the divisional commissioners. Secretary has no role to, Secretary of Transport Department has no role to this appointment. And so that so far as notification is concerned, you'll say Annexure B is there, wherein the DTO has been appointed as a certificate officer. Serial number 5. So this is notification has been issued.
You didn't ask the electricity department. I told you on that day.
Yes, yes.
You didn't consult. Not required.
I've talked to the Department of Transport. They have said it is there, Your Lordship. The facts which Your Lordship have, queries which you have raised, it is there, Your Lordship. But fact remains that another appointment can be done only by the district, Your Lordship, after taking sanction from the.
आपको मेरी बात समझ नहीं आ रही है, आप सुनना नहीं चाहते. It is very, very common
Yes.
that persons work in dual capacity, right? So I just wanted to know, this is a very, very regular thing by the electricity department. So I asked you, you ask them, they will tell you how these appointments are being made. Even the electrical executive engineer are appointed as certificate officer. सब पूछे ही नहीं, आपको कोई मतलब ही नहीं है. His only case there is that he cannot become judge in his own case. These are all recovery proceedings. The amount is already crystallized. What is that? What is that he will become a judge in his own case? The amount is already quantified. So far as the objection is concerned, they will see the objection prima facie. What is their case?
Even their lawyer has appeared before the certificate. They did not harp on the interpretation which they are claiming in this writ application that they have filed. They are not harping on that one before the and there is a claim of lump sum of 6
The objection has been filed.
as per him, Your Lordship, but
Objection has been filed. Where is your objection? Did you file your objection?
Petition has been filed, objection not.
The right to file objection has also gone.
No, right of objection. My only submission to Lordship.
We will consider it. I just want to know. We will not have an academic discussion.
That man saying not.
We will not pass an academic order. We want to see that after the receipt of the certificate notice, did you file your objection or you did not file your objection?
Lordship kindly should. पेज एनेक्सर 5 में हमने लिखा है ये जाएगा
not filed any objection. Para 12 of the counter.
Why have you not filed your objection?
काउंटर
You want to file it? If you have not filed your any objection, how are you concerned who will dispose it of? Yes?
Your Lordship kindly come to page 16 of Annexure 5.
Page number?
Page number 16. In which we have said that the vehicle which was initially registered at Delbar was shifted to Banka after.
So that is on merit. This is on merit.
That what we have said.
Yes.
That is there, page
This is
16.
not your objection.
I have not said about there is no answer to say no objection. Section 9 objection has not been filed. It could not be filed. You are also calling where will the section 9 objection be filed? Before the person will.
Certificate is of Bihar and Odisha Public Demand Recovery.
Section 9 will not exist. And then section 10 will come into force.
Certificate proceedings are essentially in the nature of execution proceedings, isn't it? Right. See the we are board's miscellaneous instructions. देखिए board's miscellaneous instructions. तो आप अपना आर्गुमेंट आप कंक्लूड करिए. चलिए आप आर्ग्यू करिए. उनका एफिडेविट आ गया है, यू आर्ग्यू विद दिस.
Then Universal Planning comes to section 7 of the Act.
First you give me the facts of your case and then to the section.
The facts of the case is not that initially law. The vehicle was initially registered before the district transport officer paid her. Subsequently, not after paying the taxes and other aspects, registration was completed, and then the vehicle was shifted to Banka, and the district transport officer obtained no objection certificate from the original authority. They did not answer it. Therefore, in view of the provisions of the Act, it was deemed that there is no objection in the transfer of the vehicle. That is also kindly come to section provisions.
No, you see, there is a certificate proceedings.
Yes.
You are questioning the jurisdiction or whatever of the certificate proceedings.
Initially,
So you confine yourself to the jurisdictional issue. The background is that you were a certificate was issued.
Yes.
Where is that certificate? Where have you annexed it? Where is that certificate?
Certificate general and access 4 में देखा जाएगा.
Annexure 4.
Page serial number 21 is general है.
जनरल कोई चीज थोड़ी होता है. आपको तो अलग से नोटिस हुआ होगा.
नहीं,
आप एफआईआर नहीं हो रहे होंगे तब आपके ऊपर.
नहीं, अलग से नोटिस कुछ नहीं, यही हमको हुआ है.
तो
उसके बाद
वारंट ऑफ अरेस्ट है.
हाँ, तो उसके बाद वारंट ऑफ इसी बेसिस वारंट ऑफ अरेस्ट हुआ है.
नहीं नहीं.
यही फैक्ट है।
किसी अदा आपके विरुद्ध उड़ीसा लोक मांग वसूली अधिनियम 1914 की धारा 38 के तहत गिरफ्तारी वारंट आदेश निर्गत कर कार्यान्वयन हेतु संबंधित थाना को भेज दिया गया है। ये वारंट तब इश्यू होगा जब आप नहीं अपियर हो रहे हैं।
सवाल ये उठता है कि हमको जो सर्टिफिकेट प्रोसीडिंग स्टार्ट हुआ है ऑन द बेसिस ऑफ एनेक्स 4।
एनेक्स 4 के बेसिस में सर्टिफिकेट प्रोसीडिंग नहीं स्टार्ट हुआ है सर।
तो काउंटर में कहाँ से बात है?
काउंटर का कोई जरूरत ही नहीं है। दिस इज सो क्लियर।
नहीं
कहाँ है एंटायर प्रोसीडिंग? आप निकाले हैं सर्टिफाइड कॉपी? वेयर इज द एंटायर प्रोसीडिंग ऑफ द सर्टिफिकेट ऑफिसर? Once the certificate is filed before the certificate officer, he issues notices to the certificate debtor, and upon receipt of the notice, they are supposed to come file their objection, whatever. And if they do not file the objection, that's a warrant of arrest is issued.
अब इसको पूरा पढ़ दिया जाए।
पढ़िए पूरा आप
एनेक्स 4 पढ़ा जाना था।
पढ़िए पढ़िए।
आपका वहाँ डिमांड नोटिस भेजा गया जिसमें 15 दिन के अंदर निर्देश दिया जाता है कि हमको डिमांड नोटिस भेजा गया। हमको डिमांड नोटिस भेजा गया। हमको सेक्शन 7 का नोटिस नहीं भेजा गया। खुद कहता है एनेक्स 4 में। ये न्यूज़पेपर कटिंग है।
आप ही लगाए ना?
हम ही लगाए।
तो बस
जो मिला हम नोटिस लगाए, उसमें लिखता है कि डिमांड नोटिस आपको भेजा। तो डिमांड नोटिस हमको आप भेजे हैं, ठीक है, लेकिन आप सेक्शन 7 का तो नोटिस नहीं भेजे हमको।
कहाँ लिखे हैं? आपका रीट पिटीशन में है कि हमको नोटिस मिला नहीं मिला, सेक्शन 7 का नोटिस इशू किया नहीं किया? कहाँ है आपका? कुछ भी नहीं है आपका इसमें। तो क्या होगा? वारंट ऑफ अरेस्ट क्वाश करके तो क्या ही होने वाला है? हम आपको वापस उसी के पास भेजेंगे ना।
किसके पास?
For filing your objection.
Against the person who has.
Yes, we will decide that issue. Whether that person can hear your objection or not.
You have to decide that.
But that is the only point you have to argue.
For the present, I am arguing to that.
For the present एकदम finally है।
नहीं हम तो
आप कुछ प्रोविजन ऑफ लॉ रिलाई करना चाहते हैं, कोई जजमेंट रिलाई करना चाहते हैं तो देखिए।
I am only submitting my lord here that whether a certificate holder can be a certificate officer. I am only asking for that. You will also decide this.
We will decide it. Don't worry. Okay. A supplementary, is this supplementary contract affidavit? A contract affidavit has been filed on behalf of respondent number 1 dated 25/11/2024, which is taken on record. The learned counsel for the petitioner submits that the solitary point which he wants to argue in the present case is as to whether the district transport officer Devghar, who is the certificate holder, could also be the certificate officer of the present case. He has submitted that the objection, if any, that may be filed in terms of Section 9 of Bihar and Orissa Public Demand Recovery Act has to be filed before the certificate officer. And since the certificate officer is a certificate holder, he cannot be a judge in his own case, and therefore the present petition has been filed. During the course of argument, no other point has been argued. The Just a minute. The learned counsel for the respondent has submitted that there is no legal impediment in the, there is no illegality in the appointment of the certificate officer in the present case. He has referred to paragraph 8 and 9 of the supplement of the counter affidavit filed today. And he has further submitted that the district transport officer from serial number 1 to 14 of the letter dated 6/1/2020 were appointed as a certificate officer by the sanction of the commissioner, who sanctioned the same by letter number 143 dated 5/10/2018. We have submitted that the notification has been annexed, which is in terms of section 3 within bracket 3 of Bihar and Odisha Public Demand Recovery Act. The learned counsel has also submitted that the recovery through certificate proceedings is essentially in the nature of execution. That's it?
Yes.
Arguments concluded. एक judgment का date January 15th के आसपास.
That's why I'm reserved.
Yes, of course. I'll decide it. आप लोग तो कोई रिसर्च करेंगे नहीं, हम अपने से कर लेंगे.
नहीं रिसर्च कर लेंगे.
I don't worry.
हम
I
रिसर्च
don't
कर
worry
लेंगे.
about
अगर टाइम देगा तो फिर रिसर्च कर लेंगे.
हम कर लेंगे. अब अभी तक आपने किया है तो आप क्या ही करिएगा.
अभी क्या
चलो.
Item 8, WPL 5260 of 2023.
We had challenged the order passed by the Labour Tribunal, and there was an application of 17B that the respondent
Yes,
had
that you have,
filed.
that
is
you have
allowed.
got it. You have got the money.
No, Lordship.
We have
They
referred
have
an
referred the
LPA
LPA, Lordship, just 2-3 days back.
22nd of November it was filed.
Then we'll hear it at thereafter.
Yes, Lordship. Because
We'll hear
they,
it here. We will not hear it unless you comply with this. Okay, WPL number 5260 of 2020. The counsel for the petitioner has submitted that
28th October
an
2020.
appeal has been filed against order dated
28th October.
28/10/2024. Number
Filing number is 12335 of
with filing number
335
12335
of 2024. It was filed on 22nd November
of 2024.
of 2024.
24, yes.
Filed on 22nd of November.
November.
Just 2-3 days back.
The petition is still defective.
Your defects have not yet been pointed out.
He submits that the office has not yet pointed out the defects. Considering the aforesaid facts, let this matter be posted on High Court. 4th of February 2025 or after disposal of the LPA, whichever is earlier. इतना टाइम तो बनता है ना.
नहीं.
अगर आपको जल्दी है तो आप appear हो जाइए.
नहीं.
आप
I'm not
appear?
opposing it, Lordship. I'm not
4th
opposing.
February.
4th February.
Much.
Under heading for orders, item 9, WPC 2167 of 2018.
In this case, the notices were issued to the respondent number 1 to 7. Now the office note says that except note respondent number 5, who has been reported to be dead. All notices have been served.
WPC number 2167 of 2018.
And they will not 2 weeks time.
Counsel for
Take
the
appropriate
petitioner,
steps for
as
substitution.
per office note, respondent number 5 has expired. Counsel for the petitioner seeks adjournment. Post on 4th February.
उससे पहले जनवरी में कोई नहीं ताकि उधर सूट चल रहा है हम इंफेक्शियस
वहाँ सब्स्टिट्यूट करा के आइए ना.
वहाँ सब्स्टिट्यूशन पिटीशन दिया
हाँ तो आप करा के आइए, वहाँ ऑर्डर करा के आइए.
जनवरी में इफ पॉसिबल
नहीं, आप पहले सब्स्टिट्यूशन वहीं पर होगा, वहाँ से करा के यहाँ ऑर्डर लगाएंगे तभी होगा.
वहाँ तो ऑलरेडी कर चुके हैं इसीलिए
सब्स्टिट्यूशन हो चुका है वहाँ पर.
पिटीशन दिए थे हम तो डिफेंडेंट वहाँ सब्स्टिट्यूशन पिटीशन हम लोग खुद दिए प्लेंटी पर
हाँ तो आप उसको कराइए ना, आप उसको कराने से क्या ही करेंगे. सब्स्टिट्यूशन वहीं पर होगा ना.
हाँ वही उसके बाद हम कॉपी लगा दें.
Item 10, WPL 5860 of
The
2024.
counsel for the petitioner shall bring on record the substitution in connection with the deceased respondent before the learned court. The certified copy will file.
Item 10.
Petitioner. It's fresh filing.
My
Wakalatnama has been filed.
for Tata Steel, I have filed. Respondent
Where
number
is the
two.
petitioner?
My lord, two names were the Basu Padmi.
What is the nature of injury?
My lord, this case is not maintainable. They have prayed for, actually they have asked for the Honorable Red Court to act as an executing court for a payment of gratuity order and in case of a money suit order.
What is the prayer?
My lord, their prayer is twofold. The petitioner is an ex-employee of Tata Steel. He is claiming that the first prayer is that letter whereby the gratuity has been forfeited. The first prayer is for quashing of this letter. The second is that the ALC Central, the second prayer is that the Assistant Labour Commissioner Central has passed an order in the petitioner's favour which we are not executing. So here the prayer is for the Honourable Red Court to execute that order. After that there's a reference to a money suit.
So far as Payment of Gratuity Act and grievances arising thereof is concerned, there is a specific provision that is the Payment of Gratuity Act,
Yes.
and it is a self-contained code in
Yes,
every aspect.
And yes, and there's an appellate authority. We have preferred an appeal. Even if we had not preferred an appeal, Your Lordship, the ample power is there before the controlling authority to execute their orders. The interesting part is that they have made the state of Jharkhand as the first respondent instead of the central government. This arises out of our minds. So the appropriate government in this case will be the central government under the Payment of Gratuity Act. So there's misjoinder of parties also. The state of Jharkhand has no role as far as the gratuity part is concerned. But the central government is not a party. In almost,
What is this execution order?
well, that is a lot of details are there. I've been partly briefed that there was some employee against whom the petitioner had certain claims. He went in, he filed a suit against that particular employee. An order was passed against which we were asked to forfeit certain amounts. We filed an intervener which was dismissed. Your Lordship. I don't know what the High Court's role will be there. We have also preferred an appeal against this order also. It's an execution case arising out of a money suit. Until I have the full details, that part I will not be able to answer. But it was originally originated from the petitioner's claim against another employee of ours. Where was the writ line? That is the issue.
Let's read Annexure 1.
Well, that is our letter. Forfeiture of superannuation benefits including gratuity for committing fraud.
It doesn't have a date. 22nd March 20. Okay. Yes.
This is to inform you that your daughter, namely Neetu Kumari, had filed a writ petition civil number 27012 of 2019 against Tata Steel, falsely alleging damage caused to her residential house due to blasting by the company during mining operations. While preparing counter affidavit on behalf of the company in the above petition, the officials searched for all records relating to your employment with Tata Steel and found that you have taken unwarranted benefit from the company by misrepresenting the company, tampering of records and committing fraud. Had the above been discovered during your tenure of service, you would have been terminated from service. Please be informed that the management has already initiated criminal proceedings against you for the misrepresentation and fraud committed by you. Further, the company is entitled for recovery of its losses to the extent of rupees, and hence the management is hereby forfeiting a sum of 1,34,121 towards your superannuation benefits and rupees 14,16,499 towards gratuity. The company reserves its rights to recover the balance amount and may further initiate appropriate legal action against you.
This is absolutely against a private party. The relief is absolutely against a private party.
Totally against a private party.
This order under Payment of Gratuity Act has been passed on 15th of March 24. This
Lordship.
letter was issued prior to that.
Well,
Whatever, this could have been a matter of adjudication or no adjudication, we do not know. And if there is any forfeiture or any recovery or anything, then that will be taken care of either through the labor court or whatever, but at least
Whatever.
not in a writ petition.
absolutely, ma'am. That was my
WPL 5860 of 2024. Nobody appears on behalf of the petitioner. The learned counsel for the respondent. Number?
My lord, I am for 2 and 3.
Respondent number 2 and 3 has submitted that the impugned order in the present case has been passed by respondent number 2 and 3, which has been challenged. Essentially, the relief is against private party and the writ petition is not maintained. He has also submitted that the impugned order dated 22nd of March 2023 relates to forfeiture of certain amount relating to gratuity, and the order has already been passed by the competent authority in connection with payment of gratuity on 15th of March 2024. 15th March का order है ना?
Yes, Your Lordship. Your Lordship may also record that appeal is pending.
The learned counsel for the respondent has also submitted that appeal against the order passed by the competent authority under Payment of Gratuity Act has been filed by the respondent, which is pending. Considering this court prima facie finds that the entire relief is against private parties. However, in order to give one more opportunity to the petitioner, post this case tomorrow. कल नहीं आएंगे तो order ही कर देंगे.
Under heading for admission, item 11, WPC 5729 of 2012.
Petitioner? Where is the petitioner? Where is the petitioner? What is it?
In this matter, Lordship, I pray for Lordship 1 week's time, Lordship.
उनके आते ही आपको 1 week time को याद आ गई?
He has no local system, private वाले.
I am appearing for respondent number 7, Lordship, the private.
ये बार-बार टाइम लेते हैं और सिविल सूट में ये हार चुके हैं और अपील पेंडिंग है वहाँ. And the matter is, my lord, that on auction we had purchased, my lord, the cold storage in Pakur, my lord. Now, which was the delivery of possession was given by the order of this Honorable High Court, and thereafter this was given, my lord, in 2011. Now, thereafter, my lord, the sale deed is not being executed and registered for which, my lord, there was an order of the additional collector, my lord, restraining the transfer. Now that order we had challenged, my lord, here as annexure in para 1A, my lord. That is the first prayer, that letter number 471 dated 27th of September, my lord, passed.
Who is in possession?
We are in possession, and possession is admitted during the writ application. The order will also show of this honorable court that the possession has been given to us, which was stated by the Bihar State Finance Corporation, Lord, before this honorable court in the earlier writ application, and that the possession has been given. So this is in our possession since 2011, Lord. And now that order, which was restraining order that was passed by additional collector, which has been impugned, my lord, before this honorable court in this writ application. Now, after considering the entire pros and cons, my lord, that has been taken back, my lord, by the government. And the government has said that the Jamabandi number 54, Jamabandi number 58, my lord, of Maja Gokulpur is a Rayati lands and is transferable. So therefore,
where is that? Where is that order of the
Lord,
government?
we received that order only yesterday.
जो आप अपना पॉकेट में रखे नहीं
नहीं, कल ही मिला है हुजूर हम लोग।
क्या ही करें हम लोग? उसके आपके पास ऑर्डर रहेगा तो उसके बेसिस पे हम यहाँ पे ऑर्डर थोड़ी कर देंगे।
तो एक सप्लीमेंट्री से हम ला देते हैं हुजूर। इसमें भी that the order that we have challenged here, memo number 471.
ये 3237 कौन सा केस है? देखिए तो
This is the order also. That's why I was telling you. A similar order was challenged in this case also in this case.
Letter number 471, Lord, dated 27 September 2008, जिससे restrain कर दिया था कि जमाबंदी number 58. Now that has been, Lord, taken back by the, and it was found that no, it is transferred.
This particular letter number, letter dated 27/9/2008, has been withdrawn.
Has been withdrawn. My lord, I bow to my lord.
If it has
By
been
this
withdrawn,
order.
just a moment. If that letter has been withdrawn, then this case has become infructuous.
Infructuous नहीं है, इसमें prayer है हुजूर कि वो सब रजिस्ट्रार को कम से कम खाली
नहीं, हम
नहीं हो तो
यहाँ
हम विड्रॉ करते हुए हमको डायरेक्शन दे दिया जाए, वहाँ एक रिप्रेजेंटेशन देंगे in view of this order, Lord.
This 27/9/2008 order, according to you, has now been withdrawn.
My lord.
It does not exist anymore.
By the government.
So therefore, whatever your right flowing therefrom, you can proceed in accordance with law.
हुजूर यही करते हैं, हम विड्रॉ करते हैं हुजूर, वहाँ पर एक रिप्रेजेंटेशन
I will record your submission that this letter has been withdrawn by the government.
Lordship, my submissions may also
हाँ,
be recorded,
Lord,
Lordship.
Lord,
That submission.
Because Lordship, I am the respondent number 7 in this, and this petition
7
has been
is
filed, Lordship, without including me as a party, Lordship. I have filed
You
and
see, just a moment. This writ petition has become infructuous for
Lordship,
all practical purposes.
Lordship, I only submit, Lordship. They want an order. They want an order from this honorable court that the registry may be, the sub registrar may be direct.
आप सुनिए, थोड़ा order आप सुनिए, आप देखिए कितना balanced order है. You
Lordship,
just
मेरा एक
hold
submission-
for a moment.
Lordship, मेरा एक submission
My
है.
lord.
कोई submission की कोई जरूरत नहीं है. जो impugned order है, according to him, that has been withdrawn. I will record that this writ petition has become infructuous. Parties to proceed in accordance with law. फिर क्या दिक्कत है आप?
No, कोई दिक्कत
बस WPC number 5729 of 2012. Heard the learned counsel appealing on behalf of the parties. District petition has been filed for the following reasons. The learned counsel for the petitioner has submitted that that the letter impugned in this case, being letter number 471, dated 27/9/2008, written back at annexure 11, has now been withdrawn, and therefore appropriate order may be passed for registry of the property involved in the present case. The learned counsel, appearing on behalf of the respondents, has submitted that if the letter has been withdrawn, then this writ petition has become infructuous. It may be kept open to the parties to proceed in accordance with law. Right? After hearing the counsel for the parties and in view of the submissions made by the learned counsel that the impugned letter dated letter number 471 dated 27/9/2008 within bracket annexure 11 has been withdrawn on instructions has been withdrawn for all practical purposes. The prayer made in paragraph 1 within bracket A has become infructuous. It is sufficient to observe that the parties may proceed in accordance with it.
But we will file representation लिखवा दें.
कुछ रिप्रेजेंटेशन का जरूरत नहीं. आप अपना आपका राइट है, आप कहीं पर भी रिप्रेजेंटेशन करें.
साइन कर दीजिए.
एक टाइम क्या हुआ?
You just proceed in accordance.
Item 12 WPC 1709 of 2019.
The EF has been filed, and it seems that the order which has been passed by the statutory authority at page number 97 under section 38(3), that statutory authority's order she is agreed. If she is agreed, then there is a provision of appeal before the district magistrate under section 101 of the Juvenile Justice Act. Instead of and the point which she is taking, the point was already taken before the CWC, the Child Welfare Committee, at page number 92. Lord will see exactly the same allegations were made there also in the way back in the year 2018. And after considering this statement, the CWC passed an order in the welfare of the child, which is at page number 97. Kindly have a look at page number 97.
Much water has flown in this case.
The statutory, the law says the Child Welfare Committee is the person who is to make an inquiry regarding the welfare of the child. She makes that very allegations in that before the Child Welfare Committee also, that I had taken this money and I am ready to return, I don't want to give. But the Child Welfare Committee made an inquiry, and even in her IA she had annexed the deposition. In para 59 of that deposition, she had the Child Welfare Committee's chairman has categorically stated that I have made an inquiry in the welfare of the child and I have given the custody to the parent. Therefore, if the at the best she says that the order is by fraud and collusion. If the order is she is aggrieved, then the law provides under section 101 that an appeal is to lie before the order. Section 101, may I place 101 of the Juvenile Justice?
It is just a moment. Let us see the relief that has been prayed. Let us have a look at the relief.
इनका
These
रिलीफ
two persons
रिलीफ इनका अब हमारे ख्याल से इनको रिलीफ में आना ही नहीं चाहिए था जब the statutory authority is passed an order, then they shouldn't have come. I say that, I mean, this is a, but the relief which the respondent is asking, I mean, that is against the, so long as the statutory authority's order is there on the file. Page number 97, statutory authority passed the Child Welfare
Page
Committee.
number
97. Passed an order. The order, if it is wrong or incorrect and she is agreed, then there is a provision for appeal. Under section 38.
Just a moment, let's have a look at this. Page number 97 is the order.
Order. Order for placing the child under the care of the parent, guardian, etc. By the order of the Child Welfare Committee, statutory body created for this purpose, custody of the child was given to me. And prior to that, in page number 92, the allegation that she is now making was already made before the Child Welfare Committee.
This Child Welfare Committee, while passing the order, has taken the consent of the
taken the
biological mother.
consideration and इन्हीं के आईए में जो
They have
गवाही
taken the consent of the biological mother.
यहाँ पेज नंबर 59
There is a biological mother existing.
she वहाँ पर ही तो वो स्टेटमेंट दी है. She gave that very statement. जो अभी
The
यहाँ पे
biological mother was a minor.
a biological mother gave a statement before the CWC.
She was a minor.
Yes,
She
Your
said.
Lordship.
Yes.
Yes, Your Lordship.
She was a minor at that point of time.
She says so.
And the
She
petitioners
says things. Do
knew
you have
that.
any doubt on that?
I can't say. I mean, inquiry was made by the statutory authority. Inquiry, if an order is passed by a statutory authority, there is a provision for appeal before the district magistrate.
Where is her statement before the authority, objection or consent, whatever?
Page number 92.
90.
यही जो सेम किस्सा है, सेम किस्सा वहाँ
ये ना बच्चे की बात है ना, इसे किस्सा कहानी की बात नहीं है.
The welfare the child was taken into consideration by the child welfare committee. इन्होंने लगाया है गवाही उसकी.
हाँ जरा पढ़िए पेज नंबर 91 और 92 दोनों.
ये. And this is prior to the order passed by the CWC.
आप पढ़िए जरा.
ये 7वें महीने का है.
91 and 92 दोनों.
जी. सच अग्रवाल, प्रीति अग्रवाल मेरे शाला देव कुमार प्रधान की बेटी है. प्रीति अग्रवाल सौरभ अग्रवाल की शादी 6 वर्ष हो चुके, उनको बच्चा गोद लेना चाहते हैं.
नहीं ये नहीं, पेज नंबर 91 पहले पढ़िए. 3/7/18 को CWC के समक्ष.
जी.
हाँ पढ़िए.
हाँ. तो समक्ष सौरभ अग्रवाल सचिन सचिव और उपस्थित बच्चा अनिमा के निर्मल सचिन सच से गायब होने का आरोप लगाया. बैठक की गई, जानकारी में निम्नलिखित है.
ये एडॉप्शन कब हुआ? What is the date of adoption?
ये ऑर्डर है.
आप डेट ऑफ एडॉप्शन बताइए ना. You are the person who has taken the child.
18/8/2018. That is the order.
नहीं ऑर्डर नहीं, एडॉप्शन का डेट.
एडॉप्शन के लिए ही ऑर्डर होता है. जो एडॉप्शन आप फिर नहीं कर सकते हैं. सेक्शन 38 कहता है कि एडॉप्शन के पहले एक इंक्वायरी होगी, चाइल्ड वेलफेयर कमेटी एक इंक्वायरी करेगी और उसके बाद चाइल्ड का
तो
कस्टडी.
3 साल ये जो एडॉप्शन का ऑर्डर हुआ है 13/8/2018 को हुआ है.
जी.
ठीक है.
लॉ जो है इसको देख लिया जाए.
जस्ट लॉ देखेंगे ना, बाद में थोड़ा फैक्ट देखते हैं.
हाँ फैक्ट्स.
लाइक पेज नंबर 97 में there is an order for placement of the child, right?
जी.
This is order dated 13/8/2018.
जी.
Correct? ये पेज नंबर 91 में
7वें महीने का है.
7वें महीने का है. ठीक है ना, उसको पढ़िए थोड़ा ठीक से.
7वें महीने के ऑर्डर को उन्होंने कंसीडर किया. इनकी गवाही में इन्होंने खुद लगाया है.
एक सेकंड, आप दूसरा कोर्ट में जाना है तो बोलिए. ये बच्चे की बात है ना, ऐसे नहीं छोड़ेंगे. ठीक है. ऐसे हर चीज में ऑल्टरनेटिव रेमेडी नहीं चलता
हर चीज का नहीं.
हम लोग को देखना है कि ये ऑर्डर होने के पहले बच्चा चला गया था आपके पास कि उसके बाद गया है बच्चा. This is what I want to know.
बच्चा ये इनके कस्टडी में दिया गया, इसी के लिए ना उसका पेरेंट्स आकर के शिकायत किया.
ये जो बच्चा है ना, जहाँ तक हम लोग को मालूम है, अभी तो आप नए आए हैं इस केस में, जहाँ तक हम लोग को मालूम है इस बच्चे को ऑलरेडी ये आपके पास दे दिया गया विदाउट एनी प्रोसीजर.
हाँ तो उसको
उसके बाद आकर
नेक्स्ट डे वापस उसको मंगाया गया.
नेक्स्ट डे नहीं हुआ है, आफ्टर सम टाइम और व्हाटएवर.
1 month and a half.
उसके बाद जो है वो बच्चे को ला के ये चाइल्ड वेलफेयर कमिटी वो जो बच्चा लेके गया था उसको रेगुलराइज कर देंगे. ये कौन सा प्रोसीजर है? इसको तो हम ऑल्टरनेटिव रेमेडी में नहीं भेज सकते. ये किस तरह का प्रोसीजर है? पोस्ट फैक्टो अप्रूवल है. ये प्लेसमेंट ऑर्डर नहीं है. पोस्ट फैक्टो प्लेसमेंट ऑर्डर.
तो ऑर्डर को तो सेट असाइड करना
कोई बात नहीं, करेंगे ना, रीट में नहीं कर सकते क्या?
नहीं कर सकते हैं तो रीट में
नहीं, ये बहुत सीरियस बात है ना, इट्स समथिंग वेरी वेरी सीरियस।
सीरियस बात है। 2018 की बात है। 2018 के बाद अपील का रेमेडी था सेक्शन 101 में, 1 मंथ के अंदर में शी हैड एन ऑप्शन, शी कुड हैव गॉन बिफोर द डिस्ट्रिक्ट मजिस्ट्रेट। उसके बाद 2021 में लॉ चेंज करके आज के डेट में डिस्ट्रिक्ट मजिस्ट्रेट को कस्टडी देना है और अपील लाइक करती है कमिश्नर के यहाँ। अब क्या होगा इस स्थिति में?
इसीलिए ना रिट है,
ये
पता नहीं चल रहा है कि क्या होगा, इसीलिए रिट पिटीशन।
नहीं तो रीट पिटीशन उन्होंने नहीं फाइल किया ना।
आपने क्या चीज के लिए फाइल किया? आपने रिट पिटीशन क्या चीज के लिए फाइल किया बताइए?
ये
आपने रिट पिटीशन क्या चीज के लिए फाइल किया? What is your grievance? Why have you come to this court?
नॉट टू सेपरेट द चाइल्ड।
तो आप अपना विड्रॉ कर लीजिए केस, क्या ही करना है। सब एक्ट के अनुसार चलेगा, आप भी एक्ट के अनुसार चलिए।
we can
विड्रॉ इट।
मतलब उसका लीगल रेमेडी जो है वो अपना रिकोर्स में।
हम कुछ नहीं बोलेंगे, आपको विड्रॉ करना, आप सिंपल विड्रॉ कर लीजिए। चाइल्ड कहाँ पर है?
Child is with the petitioner's election.
उनको लीगली कस्टडी मिला है,
It's not legally authorized.
अब उसको तो सेट असाइड कराइए ना भाई, उसके लिए तो प्रोविजन है अपील। Nothing prevented her to come to the court saying that this order is bad. This order which is they are now asking for, reiterating the same story after 6 years.
स्टॉपिंग है क्या?
नहीं स्टॉपल नहीं है, लेकिन ऑल्टरनेटिव रेमेडी एग्जॉस्ट किए बिना अगर हम लोग रिट पिटीशन फाइल करेंगे तो तुरंत होगा कि ऑल्टरनेटिव रेमेडी आपने एग्जॉस्ट नहीं किया, और रिस्पोंडेंट ऑल्टरनेटिव रेमेडी एग्जॉस्ट किए बिना 6 इयर्स के बाद आएगा तो ठीक है, जो करना है। हमको आपसे पूछा कि विड्रॉ करना, तो उन्होंने कहा कि हम विड्रॉ कर सकते हैं। Welfare of the child was taken care by this honorable court also. In the previous order, the financial capacity the parent was asked for. The welfare of the child is to be taken care. Welfare of the mother is to be taken care. ऐसा कहीं पर law नहीं है. Welfare of the child was to be taken care.
Consent of the biological mother without that working that.
ये तो अपील का है।
प्रेयर बी क्या है आपका?
जी
प्रेयर बी, पेज नंबर 8।
ईमानदारी से अगर हम चाहें तो हम पूरा फाइल प्रिपेयर करेंगे।
1 घंटा के बाद नहीं बोले, आप तैयार हो जाइए, इतना आसान नहीं है।
तैयार होना पड़ेगा हमको,
तैयार होना पड़ेगा। You see, the lady who gave birth to the child was a minor at that point. Right? उस स्टेज में बिना उसके कंसेंट के this institution gave the child to you without her consent at that point of time.
It's a factual aspect.
It's admitted, आप खुद ही
Can we give a finding to this?
आप देखिए ना प्रेयर, आपका प्रेयर ही क्या है? आप जरा देखिए, आप ही की तरफ से गिवन इन एडॉप्शन ऑन 15/5/2018 आप लिखे हैं आपने कि आपको एडॉप्शन में मिला है 15/5/2018 में बाय द निर्मल हृदय मिशनरीज ऑफ चैरिटीज रांची। So you took the child in adoption on 15/5/2018. On that particular day, no procedure was followed.
No procedure, admittedly.
Admittedly, no procedure. तो आप क्या किए? बच्चा चुराए? क्या किया? What is the implication?
Her affidavit is there.
And therefore, that particular act of yours will be legalized by a subsequent order. How we are going to accept it? बताइए। यही मनाइए कि अभी तक क्रिमिनल केस नहीं हुआ।
And your lordship?
नहीं, क्रिमिनल केस हुआ, चार्जशीट हमारे ऊपर नहीं हुआ, हम ही ने किया था क्रिमिनल केस।
बहुत अच्छी बात है। On the day on 15/5/2018, without following any procedure, the child was given to you? Who is Nirmal there to hand over the child to you? Who are they? कोई चैटल है क्या कि उठा के दे दिए किसी को?
In fact, they did not hand over, Your Worship. 16th, the child and the biological mother was handed over to the mother of the biological mother on 16th.
16/5.
Yes, Your Worship. And the 15th, they allegedly forced the.
आप तैयार हो जाइए सर, इतना आसानी से विड्रॉ नहीं होगा, इसमें ऑर्डर होगा, विड्रॉ नहीं होगा ऐसे.
And
यू गेट रेडी.
ठीक.
और आप अपना लिस्ट ऑफ डेट्स कुछ बनाए हैं? वेयर इज इट? ऐसा नहीं करिए भाई, इट्स समथिंग वेरी सीरियस. यू रेफर टू द प्रोविजन ऑफ लॉ एंड देन यू कांट परमिट दिस. अगर कंसेंट दे देती बायोलॉजिकल मदर तो हम लोग कुछ सोचते, बट एज ऑफ नाउ शी इज डिनाइंग कंसेंट.
15/5/18 का.
अच्छा एक बात बताइए, अगर मान लीजिए
कंसेंट उनका एफिडेविट है.
नहीं एफिडेविट सुनिए एक सेकंड.
कंसेंट
If a biological mother gives a consent that you take it in adoption, without following any procedure, can the child be given in adoption?
She gave an affidavit and she pretended to be major. 2 महीना का खाली फर्क है. 2 महीना का खाली फर्क है.
एक दिन का भी तो मेजर माइनर हो जाता है ना. कहाँ लिखा है कि
Anyway,
आज
I mean, I was misled. हो सकता है.
Your Lordship, it is very clearly said by his statement that he prepared. He asked them to make the affidavit. So he prepared the
तो
affidavit.
जब दोनों जने राजी होते हैं ना तो इसी तरह के एफिडेविट बनते हैं. ये भी बात उतना ही सच है. You just नहीं, we have seen it. You just prepare it. ये withdraw नहीं होगा, यहाँ से clear order होगा.
ठीक है. अच्छा.
इसलिए withdraw का कोई स्कोप नहीं है. आप लोग तैयार हो जाइए. Pleadings तो complete है. You have given your affidavit that you want to retain the child.
Yes, Your Lordship.
छुट्टी के पहले होगा ये ऑर्डर.
हाँ.
Every day is important for the child.
ठीक.
बताइए कब करिए. नेक्स्ट वीक कर लीजिए. नेक्स्ट वीक
10-12 रोज का कर दीजिए खाली.
ठीक है, 10-12 रोज.
इसमें 2-3 चीज को देखना होगा. उसमें एक्ट में ही प्रोविजन है, अपार्ट फ्रॉम चाइल्ड वेलफेयर कमिटी, एक ये जो सोशल जैसे निर्मल हृदय टाइप की चीज है, इनको गवर्नमेंट रिकॉग्नाइज करती है
कि अडॉप्शन में दे सकते हैं.
इनका भी प्रोविजन है. हम उस प्रोविजन को भी अभी बताएंगे उसमें क्या है. और चूंकि इनको उस वक्त में बच्चे की मतलब फॉर वेरियस रीजन निर्मल हृदय में थी, क्या उनका परेशानी था,
उसमें
मेंटल एस्पेक्ट को भी देखना है. लेडी
सर्टिफिकेट है कि मेंटली सिक है.
नहीं, मेंटल एस्पेक्ट मतलब अगर ट्रॉमा में है,
ट्रॉमा में है तो बच्चा को दे दी, तब तो और भी ज्यादा इलीगल.
नहीं, ट्रॉमा में
मतलब लेडी इज इन ट्रॉमा, मदर इज इन ट्रॉमा,
लेडी के लिए एक बच्चे को लेकर के रखना थोड़ा सा उस परिस्थिति में, जबकि
तो चाइल्ड वेलफेयर
सोशल स्टिग्मा का डर होता है.
कोई स्टिग्मा का डर नहीं. नाउ शी वांट्स अ चाइल्ड. अब उसको कोई सोशल स्टिग्मा,
वो तो 2018 में भी चाह रही थी. उसके बाद सीडब्ल्यूसी ने ऑर्डर पास किया. The order was right or wrong, उसको चैलेंज कभी किसी ने नहीं किया. आज इनको
देखिए आज के दिन में अभी तक हम लोग को लग रहा था the lady might be ready to have the child retained with you, maybe considering the future of the child etc. There may be so many aspects of the matter. अगर वो एग्रीमेंट होता तो 226 में हम लोग कुछ करते कि इसको लीगलाइज करते, चाहे कुछ भी करते, क्योंकि अदरवाइज एवरीथिंग इज ऑफ द पास्ट. But as of now, she has filed an affidavit that she wants the child back.
Resigning from earlier affidavit.
Yes, she can. We'll see that.
She has become wiser than what can I do? We'll take child interest protected कहाँ पर है? इस aspect पर भी think करें.
Child का welfare. बच्चे के माँ बाप गरीब हो, चाहे अमीर हो, चाहे भिखारी हो, चाहे राजा हो, चाइल्ड का वेलफेयर चाइल्ड के माँ बाप से बेहतर कोई नहीं सोच सकता है, ना कर सकता है, ना हमारा सोसाइटी और लॉ ऐसा परमिट करता है।
6 वर्ष तक तो हमने पाल दिया।
कोई बात नहीं, अच्छी बात है ना, पाल दिया तो बच्चे का भी तो प्यार पाया होगा ना।
बच्चा तो साइकोलॉजिकली हमारे साथ अटैच हो चुका है, माँ बाप हम ही को जान रहा है।
ना 6 साल का बच्चा क्या ही अटैच।
15 दिन का बच्चा था जब हमारे पास आया और 6 साल मेरे साथ रहा, स्कूल में पढ़ रहा है।
हम लोग बढ़िया स्कूल में एडमिशन कराएंगे। बताइए कौन से स्कूल में कराएंगे, बताइए।
अभी प्रिपेयर्ड नहीं है।
We have lot of money for children. उसकी आप चिंता नहीं करिए। We will take care of the child. The society, the court, the system, everybody will take care of it.
डिस्ट्रीब्यूशन तो कभी भी लॉ अप्रूव नहीं करता है। It has to be somewhere, some कोई ऑल्टरनेटिव हुजूर निकाल लेंगे ज्यादा अच्छा हो।
We'll find it out.
कब रखा गया हुजूर?
11 को आएंगे, बताइए। लेकिन उस दिन टाइम मत मांगिएगा, हम पूरा सेकेंड हाफ इत्मीनान से इसको सुनेंगे, इसको हमको डिसाइड करना है। और चूंकि बच्चे का सवाल है, एवरीबडी ऑफ अस विल बी सेंसिटिव अबाउट इट, एंड इफ द चिल्ड्रन, द पेरेंट्स, एनीबडी दे वांट टू जॉइन ऑनलाइन, दे कैन जॉइन ऑनलाइन। उनको बता ही दीजिए कि अपना चूंकि सेंसिटिव मैटर है, अपना ज्वाइन कर सकते हैं, देख सकते हैं प्रोसीडिंग। बहस करने का परमिशन तो नहीं ही देंगे, इतना दूर से आने का कोई पर्पस भी नहीं होता है। दे हैड कम, वी हैड सीन देम, राइट, दे हैड कम टू आवर चेंबर, वी हैड सीन द चाइल्ड। ऐसा नहीं है, ऐसा कुछ विशेष बातचीत कुछ भी नहीं हुई है, लेकिन वी हैव टू गो एज पर द ऑर्डर। ऑन दैट पर्टिकुलर डे द लेडी हैड कम, लेकिन उसका कोई आइडेंटिटी नहीं था, कुछ नहीं था, तो हम लोगों ने उसको परमिट नहीं किया था। शी वॉज नॉट अकम्पनीड विद हर काउंसिल ऑल्सो टू डिस्क्लोज हर आइडेंटिटी, दैट इज वाई वी डिड नॉट परमिट हर। लेकिन ये तो डिसाइड तो करना ही है।
After becoming aware of the order that the CWC has passed, given the
आपका ये ऑल्टरनेटिव प्ली का भी हम लोग कंसिडर करेंगे।
नहीं, अभी खाली ये कह रहे हैं, आई वाज लाउडली थिंकिंग व्हाई शी केप्ट मम फॉर सो मेनी इयर्स।
बच्चा जो है ना, ये इतना सेंसिटिव चीज है। एक बच्चा जो माँ से जन्म के समय बिछड़ गया, वो 50 साल बाद भी मिल सकता है, मिल सकता है ना।
हिंदी फिल्म में तो बहुत होता है।
हिंदी फिल्म में नहीं, प्रैक्टिकली भी बहुत होता है।
प्रैक्टिकली
ऐसा नहीं है।
प्रैक्टिकली अब हुजूर के आज्ञा से हो जाएगा तो अच्छी बात है।
मेरे आज्ञा से क्या ही होने वाला है, लॉ से जो होगा वही होगा, हम लॉ के बियॉन्ड नहीं सोच सकते।
इसमें कोई हार्म नहीं है कि अगर कमिश्नर के यहाँ, डिवीजन के यहाँ अपील में ये जाएं, वहाँ पर ये इंक्वायरी करके फैक्चुअल इंक्वायरी हो जाएगी। यहाँ पर बहुत ज्यादा चीज कॉन्स्टेंट्स रहता है।
फैक्चुअल इंक्वायरी क्या है, आप ही का एडमिशन
जो भी है, आई मे विन और लूज, जो भी है, कोई हर्जा नहीं है। लेकिन लॉ फैक्ट फाइंडिंग कोर्ट जो है, अगर बना हुआ फोरम, फैक्ट फाइंडिंग कोर्ट है, सेशंस कोर्ट अपीलेट बॉडी है या कमिश्नर, तो सेशंस कोर्ट में फैक्ट फाइंडिंग का मैकेनिज्म है, गवाही लेकर
सारे प्ली को कंसीडर करेंगे। लेकिन ये अल्टरनेटिव रेमेडी वाला प्ली हमको इसमें जज नहीं रहा,
उसको एक डायरेक्शन 15 दिन के अंदर में कंसीडर करने के लिए दे दिया जाए, हो गया। तो कस्टडी 6 साल है, 15 दिन में कोई हेवन इज नॉट गोइंग टू फॉल। स्टैट्यूटरी बॉडी है, उसका अपील का एक वैल्यू होगा।
द चाइल्ड गिवन इन एडॉप्शन illegally cannot be legalized by subsequent actions.
And this aspect को हमें देखिए, because ultimately I mean illegal yet another
कंसेंट होता तो हम लोग इसको लीगलाइज कर देते,
इलीगलिटी को
बहुत सारी चीजें कर देते। अगर कंसेंट होता तो हम लोग जरूर से करते।
Consent होता, she would not have come here.
No. It was not clear. It was not clear. It is only now this affidavit has been filed. पहले तो affidavit ही नहीं आया था।
Wisdom teeth होता है 22 के बाद होता है, 18 4 साल
किसी को कभी नहीं होता। चलिए। With the consent of the council for the parties post this case on 11th of December 2024, it is made clear that the matter relates to custody of child. 215. It is made clear that the matter relates to custody of child and every day is important for the child. Therefore, no further adjournment will be granted on that day. The case will be taken up at 2:15 as first case and will be continued till it is over. लिस्ट ऑफ डेट्स आप बना के लेते हैं.
Item 13 WPC 4979 of 2019.
आइए फाइल की फॉर एक्सटेंशन ऑफ टाइम बाय द स्टेट.
क्या चीज़ का आपको एक्सटेंशन चाहिए? कौन आप फाइल किए हैं?
On the last occasion, the matter was taken up, Your
हाँ,
Ladyship.
yes. Why do you need extension?
Ladyship, the settlement case to which the petitioner is relying is of 78-79. The records couldn't be traced out, Your Ladyship.
कितना टाइम चाहिए?
Lady-
FIR कर दिए हैं कि रिकॉर्ड्स नहीं मिल रहा है.
Ladyship, may kindly have para 3 of the IFDF. In the paragraph 3, we have mentioned that settlement case records could not be traced and therefore new record of the case has been constructed. And the same has been forwarded to Deputy
New
Commissioner.
record of the case.
They have, as per the order of Your Ladyship, they have come up with the entire documents and made representation before the circle officer, Your Ladyship.
Okay.
Based on the entire documents and they
How
have-
do you say that those documents are genuine?
That's why,
कैसे बनाना?
Ladyship, that's why we
If
have.
a litigant comes to you, certified copy लाएंगे, fair enough, possible. लेकिन ऐसे उनके documents के basis पे आप अपना record कैसे construct कर लेंगे?
Ladyship, we will verify the records and final order is.
कहाँ से verify करेंगे? Your records are not there. बताइए. ये procedure कुछ doubtful नहीं है, गलत नहीं है कि litigant आके document देंगे और आप record reconstruct कर लेंगे. हो सकता है क्या ऐसा? कि रिकंस्ट्रक्टेड रिकॉर्ड जो है ना ऐसे रिकंस्ट्रक्ट नहीं होता रिकॉर्ड. सर्टिफाइड कॉपी अगर दिए हैं तो बात दूसरी. इसका मतलब क्या है? जो रीट में फाइल किए हैं वही जाके आपको दे दिए हैं डॉक्यूमेंट. अब आप रिकॉर्ड रिकंस्ट्रक्ट करके वही यहाँ प्रोड्यूस कर दीजिए और ये सारी बातें मान लीजिए. झारखंड में ऐसे ही चल रहा है क्या? यस.
The records are of 70.
आप FIR करिए रिकॉर्ड्स अगर आपका मिसप्लेस होता है तो. We'll see what is to be done. इनके लिटिगेंट के डॉक्यूमेंट देने पर आप कैसे रिकॉर्ड रिकंस्ट्रक्ट कर लेंगे? If it is not the certified copy of the documents, how can you reconstruct the record like that?
Sometimes, sometime may be granted.
आप बताइए ऐसा रिकंस्ट्रक्शन हो सकता है रिकॉर्ड का कि लिटिगेंट आपको डॉक्यूमेंट देगा और आप रिकंस्ट्रक्ट कर देंगे? हो सकता है? नहीं हो सकता है ना? तब लिटिगेंट इज अ पार्टी. उसको जो मन होगा वो आपको देगा. 4 ठो डॉक्यूमेंट बना के भी दे देगा और आप वही डॉक्यूमेंट यहाँ प्रोड्यूस कर देंगे. क्या ही करना चाहते हैं आप? Your intention does not appear to be clear, or you do not know the law at all, not fit to be the circle, or you are the circle officer. यही सब करते हैं आप. लिटिगेंट देता है उसका रिकॉर्डिंग का रिकंस्ट्रक्शन हो जाता है उसके बेसिस पर. यस. Where have you stated that you have reconstructed the record? Let me make some observation on that.
Paragraph number 3, Manoj, if I am permitted to place.
Yes, please read.
That the old record pertaining to the settlement case could not be traced and therefore no records of the case has been constructed. The same has been forwarded to the competent authority, that is Deputy Commissioner, but a data details so and so. However, because of the ongoing process of the
देखिए,
state,
WPS number 4979 of 2019. A petition, IA number 12554 of 2024 has been filed seeking extension of time to comply the order dated 14/10/2024. The learned counsel for the petitioner has referred to paragraph 3 of the said petition and has submitted that old records pertaining to the settlement case could not be traced and therefore new records of the case has been constructed. And the new record so constructed has been forwarded to the competent authority, that is Deputy Commissioner Ranchi, by letter number 797 dated 16/11/2024. But because of ongoing process of state legislative assembly election, which was affidavit dated, the order has not been completed. The circle officer is present before this court. Upon a query of this court, the circle officer has submitted that since the old record were not traceable, the new records has been constructed on the basis of documents furnished by the petitioner. Yes, furnished by the petitioner. This court is of the considered view that the records cannot be reconstructed on the basis of documents furnished by a litigant unless those documents are certified copies obtained from the records. If the records are not traceable, certainly FIR is to be instituted, and then appropriate steps is required to be taken as per law. बताइए कितना टाइम चाहिए?
Pursuant to order passed with this Honorable Court last year, supplementary entry has been filed. May kindly see last order passed by this Honorable Court.
क्या supplementary affidavit
इसमें relevant document लगाने बोले थे हमारे पोजीशन के बारे में. Last order.
या आपको करना है?
हाँ फाइल कर चुके हैं.
इलेक्ट्रिसिटी बिल वगैरह सब लगाए?
हाँ लगाए हैं.
At the request of the counsel for the state, posed this case on 9th of January. पहले जाके FIR करें, फिर खुद ये रखें.
सबमिशन में पिटिशनर आ गया, रिस्पोंडेंट का सबमिशन.
क्या चीज़?
इसमें सबमिशन हमारा आ गया पिटिशनर का.
क्या?
अभी ऑलरेडी जो लिखा है
ये
उसमें
उन्हीं का.
रिस्पोंडेंट का.
Respondent का सबमिशन.
जी.
Item 14 WPC 5727 of 2019.
In this case, note the prayer of the petitioner brought in Excerpt 13, page 72. The facts of the case note is on the recorded rear, the son of the recorded rear on 25/1/1966, Anand Das, applied under sections 46 of the Chhatnapur Tenancy Act for seeking permission to transfer some portion of the plot in favor of the vendor of the present lease. That was allowed in 1966, that is Annexure 1, page 42. Then Annexure 2, page 44 is not the order sheet of 1966. Then after permission, when the sale deed was registered in favor of the vendor of the lease, who ultimately, by registered sale deed of the year 1967,
You are seeking compensation?
that is the reason I am just narrating the.
No, we have seen the facts.
Yes.
For compensation, what is the impediment? You have a remedy.
That now the impugn order debars me to seek any remedy. You will also just see for.
Where is the
I will
impugn
just explain what the impugn order says as per the report which was called for by your lordship by this honorable court by order dated 9/2/2021 and that has been brought on record by the supplementary counter. Now my lord, your lordship में can they say कि मेरा पोजीशन 1990 चूँकि हम 97 से खरीदे हैं, म्यूटेशन मेरा 97 2010 से है, तो they say that they forget about the vendor's possession and vendor's mutation. Now Annexure 3, if your lordship may kindly see page 13 of supplementary counter, it should revisit, the impugn order should revisit the other consideration. Lordship just see not Annexure B series, last page is not page 13. Page 13 is the copy of that was direction was given by this honorable to see. Your lordship just see order dated 9/2/2021 The respondents were directed
The
by the
affidavit is dated
Dated
26/9.
Yes. The short time
Annexure B
thereafter.
series. Yes.
26/9/2024.
Annexure B series.
Yes, B series, last page of my kindly. Page 13. This is the register to the mutation in favor of the vendor of the petition Anand Das.
Yes.
You also just see the name. Of course, I have been also provided the same copy, but still I have read it. Anand Mochi. Anand Mochi. You also will get note on the top. It is in the name of Anand Mochi. Registered to tenants ledger. Anand Mochi.
नहीं, हमको तो नहीं दिख रहा है इसमें।
Has you also got it?
Last page में।
Anand
हाँ,
Mochi.
आनंद name of Rayar.
Yeah, name of Rayar Anand Mochi है या Das कर रहा हूँ. I am not in a position to read, but Anand plot note is very legible. This is the in respect of the same plot note, and you also will find from the dates note which are given in 1961-62. Rent was being collected. It was mutated in 1961-62. In the name of Anand, the vendor. Then it is running in Panji 2, and thereafter you also may kindly see annexure 1. You also just see for a moment. Annexure 1, page 42. Page 42. Certified to be. This is the application because it was a land belongs to scheduled caste. Therefore, in view of the provision of section 46 of the Jharkhand Tenancy Act, before transfer there must be a permission of the competent authority. Page 42. Has you also got it?
Yes.
Anand Das is the transferor. He is the applicant. He proposed to sell it, portion not 10 decibel to Mohan Rajwar. When Mohan Rajwar, then this petition was allowed by Annexure 2, page 44. Annexure 2, page 44. This is the application which was not allowed to peruse the document produced by the applicant. It is order dated 3/2/1966. It appears that rent receipt number such and such 15/12/1965 has been issued in the name of applicant Anand Das, and from the point of view he has claimed the land. Permission for transfer of land to the extent of his share only is therefore accorded under section 46. Thereafter, you will just see another application annexure 3, page 45. It was also allowed by annexure 4, page 47. This is the same plot, not the another portion. You will get note, and then thereafter, after permission, the Rajwar, Manulal Rajwar, he purchased it, and thereafter he sold it to the petitioner and his father by annexure 5, page 48 in 1997 by registered sale deed. There are two deeds. Annexure 5, page 48 is one deed. Another deed you will also find annexure 6. Annexure 6, page 54. By the purchaser from Anand Das, he sold it to the Ramjas Sharma, the father of the petitioner, and in the first deed, father of the petitioner as well as the petitioner, both are purchased. So after purchase, they got their names mutated, paid rent to the state of Jharkhand. Annexure 7, page 57 is the rent receipt, and they also admit this fact that their names of the petitioner and father of the petitioner were mutated in 2010, and they are paying rent. That is an admitted question. Now, after the matter was remitted to the respondent number 2, who formed a committee by 3 persons, additional collector, NRDC, and the circle officer, who submitted report to the effect that since we are in possession since 1997 and rent receipt is being issued from 2010, and therefore I do not fall within the category of the interest.
Where is your representation after the order of
Yes,
this court?
you will see my kindly see annexure 12. Annexure 12, I have given the details in the documents, page 67. Page, you will see my kindly see. Para 1, on 25/1/1966, Anand Das, being legal heir of the recorded ledger, applied for permission. Then permission was granted. Then by registered sale deed on 14/3/1966, Anandas sold an area of 10 decimal to Mohan Rajwar. On 22/5/67, Anandas again made an application under section 47 46 CNTF for permission that was allowed. Again on 27/11/67, Anandas sold 8 decimal to Mohan Rajwar. Mohan Rajwar acquired total area of 18 decimal out of plot number 2462 and 20 out of 23 decimal of plot number such and such by registered sale deed dated 10/11/1997. Umar Rajwar, son of Mohan Rajwar, sold 10 decimal of land to the father and the petitioner. And the subsequently by registered sale deed dated 17/11/97, Jharkhand Rajwar, another son of Mohan Rajwar, sold 8 decimal. So we have purchased 18 decimal. Accordingly, my father and myself got our names mutated. Then this is all documents were also provided to. I am
So, with respect to this particular property,
yes, this
just a
part.
moment. Has any award been prepared in name of one
No,
or the
they
other
said
person?
it is said that in the Khatiyan it was recorded as Garmajirwa. Recorded in the name of Anandas, but it is nature of land was Garmajirwa Khas. Therefore, they say it is a government land. Now, Lord, the government came out with the two circulars. If you Lordship may kindly see for a moment.
So, government is claiming title over this.
No. What happened, Lord Lordship? Just similar to Annexure 8 and 9. Annexure 8 and 9. This is the direction by this on page 59. Annexure 8. These are the regulations taken by the government of Jharkhand. Page 59. Annexure 8 जैसी विषय केंद्र सरकार के लोक उपक्रमों की परियोजनाओं हेतु अधिजाचित गैरमजरूआ खास as you look at page 59 I am reading the contents note विषय
Where is the Khatiyan?
Khatiyan I don't have the I can produce the Khatiyan but here there is no dispute. They say yes they do not fall within the category of the lands as described in Annexure 8 and 9 because they say the lordship just similar. Here it has been decided.
The point is that
yes.
If the award, this is an award,
no, this is not an award. It is pursuant to the order of this court.
What is the remedy against this? If they are claiming compensation in connection with the property acquired for National Highway, then what is the remedy against that? Any award has been prepared with respect to this?
If the award is not prepared, Your Lordship, then the petitioner can move before the competent civil court, Your Lordship.
No, award must be prepared. Maybe
Because
that the
land
state. You see, if the land is belonging to the state will offer it to you, isn't it?
State transfer the land.
Has the state transferred the land to you?
No, there is no such document on that.
We have not filed.
See, either the state will transfer the land to you, or and you will pay some compensation to the state as per the procedure, isn't it? You pay
For
some
the
amount.
GM land, we not paid the.
But at least the state takes a decision to transfer this land to you.
There must be some document.
There must be some document,
yes.
right? If the state has transferred, then state is claiming title. Then there will be a title dispute. But if the state has not transferred this land to you, then under such circumstances, somebody has to be paid compensation for this land.
Yes, Your Lordship.
Then where is that document?
And the Annexure 8, Your Lordship, it's for the PSU, Your Lordship. Kendra Sarkar ke lok upkaram. NHI is not.
NHI is not involved.
No.
NHI से तो कोई लेना ही देना नहीं
नहीं है
नहीं है तो बोलते हैं इनको कोई मतलब ही नहीं है इस जमीन से
Sir, regarding DVC and DVC.
It is regarding DVC?
Yes, Your Lordship. Can you see the
Annexure?
contents of the वहाँ से झारखंड राज्य पुनर्स्थापना एवं पुनर्वास नीति 2008 के अध्ययन
पेज नंबर कौन सा?
पेज नंबर 59 Annexure 8
लोक उपक्रमों की परियोजनाओं हेतु अधिजाचित गैरमजरूआ खास और सरकारी भूमि को स्थायी हस्तांतरण में भूमि पर 30 वर्षों से अधिक अवधि के दखल का एवं जोत आबाद करने वाले व्यक्तियों को परियोजना के खर्च पर समान रजतों को दे क्षतिपूर्ति के
just a moment, sir. Your property has been taken by whom?
by the NHI.
Have you taken this property?
Yes, road has been
Take
constructed.
second route change.
Yes, it's under construction.
It is under construction, right?
Yes.
How did you get this property? DVC has given you this property, or the state has given you this property.
State.
From where do you get that? You bring it on record.
Yes, I will find
If the
out.
state has given you this property, then
Yes.
certainly there is a title dispute.
Yes, yes, yes. Yes, I will bring all the records.
The learned counsel for the parties are present. The learned counsel for the NHAI has praised for some time to bring on record as to how the property involved in the present case has come in possession of NHAI. She has also submitted that if the land has been transferred by the state, then also the connected documents will be placed on record.
Yes.
बस आप बोले ये काम हो जाएगा खत्म
जी।
नहीं होगा। आपको कुछ बोलना है स्टेट को, क्या बोलना है आपको?
As per the
Is it your land?
Lordship,
Have you stated so?
as per the direction of this honorable court, in earlier petition, a 4-member committee was constituted, and after looking all the facts and circumstances, order has been passed. As per the last order, Lordship, we have filed supplementary counter affidavit and annexing the report of the committee as well as Khatia. This is on registered 2%.
So you claim title over this property?
No, nothing has been said in the impugned order.
Do you claim title over this property?
He says that I am not in possession for 30 years. Therefore, I am not
If
entitled.
a person is अभी तो judgment है सुप्रीम कोर्ट का adverse possession state नहीं claim कर सकता. Do you claim adverse possession? State is claiming adverse possession.
टाइटल नहीं मांगा मुझे ऑर्डर देखा जाए impugned order.
एक बार लॉर्डशिप एक बार पेज 9 देखिए जो कमेटी का रिपोर्ट है.
आप हमको हम देखेंगे जरूर से देखेंगे. आप सिर्फ हमको इतना बताइए. Are you claiming title over this property or not?
Nothing has been said in the impugned order or in the counter.
The land is the nature of गैर मजरूआ खास तौर से, and therefore this and also it has come that since 30 years the petitioner was not in possession, and therefore it has been found that since the nature of the land is गैर मजरूआ खास, that is why it was said that it is a government land.
No.
Therefore, if this is a government land, you must have transferred it to NHAI. किया होगा ना आपने ट्रांसफर, राइट? ऐसे तो नहीं, फिर तो NHAI एनक्रोचर बन जाएगा, राइट?
There is some document.
And at the time of transfer also there is some kind of थोड़ा मोड़ा तो पैसा मिलता है सरकार को भी, नहीं मिलता है? नहीं मिलता है, अच्छा.
Free of cost transfer.
Free of cost. Then you must have transferred it. You bring that
point lordship, some instruction is
बिना ट्रांसफर के तो नहीं जा सकता ना उनके
without
पास.
transfer you cannot.
आप लेके आए जी. और अगर ट्रांसफर किए हैं तो भी आना चाहिए, तब तो टाइटल डिस्प्यूट हो गया सीधा सीधा.
तो उसके लिए जो 3H4 है,
3H4
उसके लिए my learned friend is right, then that can be decided by the competent court under the act.
करना है वो उनको लाने दीजिए पहले.
कहा कि अभी तक हुजूर नहीं आया है.
अभी आ जाएगा.
आ
उनके
जाएगा
पास
तो
वो प्रॉपर्टी का
उसमें वो जो
क्या
three-
स्रोत है, वो
3H4
कैसे आया है,
हाँ.
उसका कॉम्पनसेशन डिटरमाइन हुआ है नहीं हुआ है,
Award
वेदर
बना
इट हैज
है.
बीन टेकन एज अ गवर्नमेंट लैंड,
Transfer.
उसका अवार्ड बना है कि नहीं बना है, ये सब चीजें जी. 1 week should be sufficient.
तो अभी 3H4 हो.
Yes.
Post on 10th of December. The affidavit should be filed by 6th.
Yes.
Correct?
Yes.
अगर उनका डॉक्यूमेंट आ जाएगा तो उसको क्या ही रिजॉइंडर दीजिएगा. इट विल बी एन ऑफिशियल डॉक्यूमेंट.
ऑफिशियल होने से भी
आने दीजिएगा.
गेट सेंड.
Pass over case from supply list item 5 WPC 355 of 2020.
Give me the dates.
That's on 18. Should I give the dates of the proceeding? Only the proceedings?
Only the proceedings.
Only the proceedings, right.
When was the application
Yes,
filed?
yes. I'll give that date. The application was filed on that date, yes, on 20th of January 2017. Notice was issued to me by on 6/2/17, 3/4/17. These are the two dates when notices were issued to the petitioner. On 4/8/17, reply was filed by me. Then there are two dates, 30th of October 2017 and 5/2/18, by which this council advised me to make payment of the amount, and 6/3/18 is a letter of the council to the petitioner to clarify its stand regarding balance payment of rupees 2,88,144 after payment of rupees 22 lakhs 7,359, and then the final order is passed directing. The final order or the award is dated 23rd of March 2018. These are the only orders.
And what is the amount in the final?
The final amount is 2,88,144 is the final amount.
So, during the pendency of proceedings, you paid 22 lakhs and all.
The payments have been made. This 22,7,359 was paid.
No
So
failure
these-
report?
So
No arbitration?
No failure report, no arbitration. Straight away 18.3, they should have passed an order in terms of section 18.3, holding that the conciliation has failed, and in terms of 18.4, the matter could have been sent for arbitration. So there is no such order. These are the records have also been there received, and this is I am saying from the records.
Yes, what do you have to say?
Lord, I was relying upon a judgment of division bench of this honorable court. But under similar facts and circumstances, the conciliation proceeding was drawn, and there was no formal declaration that the conciliation proceeding has come to an end, and then the matter was not even referred to the arbitral settlement, or not the council did not undertook the did not carry on any proceeding under the arbitration act. I am relying upon the judgment of this honorable court passed in LPA number 400 of 2022. Wherein under similar facts and circumstances, there are few paragraphs. Paragraph 6 में गाड़ी है. What was the contention raised there in paragraph 6? It is on page 3. Paragraph 6. The learned counsel for the appellant has inter alia raised the following grounds. Mandatory procedure under section 18(2) of the MSME Act was not followed. Conciliation proceeding and arbitration proceeding both were clubbed together, and the award dated 24th of August 2021 has been made. The procedure for arbitration under the Arbitration Conciliation Act was not followed, and so and so was not offered any opportunity to leave evidence. Same is the case here. Lord, next paragraph, Lord Malone kindly have paragraph 15, which will make things much more clear. Paragraph 15, page 7. Yes, page 7, paragraph.
appellant contends that there was no effective conciliation by the facilitation council in as much as the facilitation council as conciliator was never involved in the process of conciliation, rather the parties were left to reconcile the differences on their own. The learned senior counsel for the appellant would submit that the proceeding under subsection 2 of section 18 of MSME Act which is a mandatory in nature, shall come to an end and terminate only upon a written declaration by the conciliator. In this context, the proceeding dated 28 October 2020 and 18 December 2020 have been referred to submit the conciliation proceeding as envisaged under subsection 2 to section 18 never took off, and moreover there is no written declaration by the conciliator that the conciliation proceeding under section 18(2) has terminated. To counter this stand, the appellant Mr. So-and-so, the learned counsel for the respondent who has referred to the procedure prescribed under section 67 and 69 of the ACA to demonstrate that the entire exercise of the conciliation under section 2 of section 18 of MSME Act was conducted by the Petition Council in accordance with the procedure prescribed under section 65 to 81. I'm going to next paragraph. The findings of this honorable court is not at page 22.
You read para 16 also.
Para 16. It is submitted that the facilitation council, which is well within its power to take up itself the role of conciliator, has afforded opportunity to the parties to sit together and reconcile their differences. And there was a statement of intimation in the form of a request by the respondent number 2 to the appellant to participate in the conciliation proceeding on the date and place convenient date. In the communication dated 25th of November 2020, the appellant had given its own counting of the claims raised by the respondent. There is no denial by the appellant through communication dated 26th November 2020 in as much as the appellant has taken a stand that there is no outstanding payable dues to the respondent, but payments have been made to the respondent number 2 at least on 3 occasions, and so and so, so and so. In the end, the respondent number 2 has put the appellant to notice. If it fails to make any proposal, it would presume that the conciliation exercise has failed. Thereafter, the respondent number 2 has communicated to the appellant through the letter dated so and so that it intends to communicate the failure report to the facilitation council, and these materials were placed before the facilitation council through supplementary affidavit dated 17th of December.
Is there any such communications involved here?
No, the communications are there. No, it is recorded in the order circular.
That the conciliation will be taken to have been failed. Is there any such communication?
No such.
That is a very important thing, no?
But there, even in that case, there was no formal declaration that the conciliation has come to.
But there were certain communications between the parties regarding failure of conciliation.
But here, if may I please refer to
okay,
the
let's
order.
see the finding.
Yeah, yes, finding is at para 22 onward. Para 22, page 11. Having examined, may I please read?
Just a moment. Para number?
22, page 11.
Yes.
Yes, having examined the materials on record, we have formed a prima facie opinion that whether or not the procedure of subsection 2 to section 18 of MSME Act have been followed by the Facilitation Council is a mixed question of law and fact. The appellant had notice of the conciliation proceeding as has been indicated in the proceeding of the Facilitation Council dated 28th of October 2020. The state proceedings record that both the parties were directed to reconcile the point of dispute within 30 days and inform the council. What has happened thereafter leads to a controversy which can be set at rest only after a detailed examination of the documents and judicial pronouncement on the subject. And the next paragraph is para 26. 26. Page 14. Page 14. Indeed, it is essence of the Arbitration Conciliation Act that minimal judicial interference should be permitted during and after the arbitral proceeding, and that is the reason section 5 of the AC Act provides that except as provided under the Act, no judicial authorities would intervene in the matter. Similarly, section 37 of the Act, which catalogs the appealable order, has also limited the scope of judicial intervention in the matter relating to arbitration. It is also well accepted opposition law that the issue of jurisdiction has to be raised first before the arbitral tribunal, as its decision holding jurisdiction to proceed with the arbitral proceeding is not open to challenge till an award is made. Section 34 of the AC Act, which provides grounds for challenging the arbitral award, lays down that the composition of the arbitral tribunal or where the arbitral procedure was not in accordance with the agreement of the parties shall be grounds to challenge the arbitral award. Similarly, clause 3 to subsection 2, section 34 of the AC Act provides that the arbitral award can be challenged on the ground that the proper notice of the appointment of the arbitrator was not given, or the arbitral proceeding, or when the aggrieved party was otherwise unable to present his case. The
It was
expression
relegated for 34.
Then-
Rather, no right was given to move 34 also.
In this case, no, the learned writ court had directed to avail the statutory alternative remedy under section 34.
Where is that direction?
The writ, para 3. Para 3 is the writ court's judgment order has been quoted. Page 2. I'm skipping certain few lines more, and then this court is of the view that this said rival factual claims of the parties inquire detailed examination by leading evidences which can effectively be.
That is clearly on facts. That is clearly on facts.
Facts are somewhat
Now
different.
there are two judgments also. You are facing two judgments of the Honorable Supreme Court. Right? You are relying upon this judgment. Those two judgments of the Supreme Court, what do you have to say?
Well, those two judgments must say that the award must be having the trappings of this arbitral award. Then only section 34 can be applied.
If it is no
It is
award,
there.
the matter ends. Then under such circumstances, it's a nullity. The only remedy is that we can refer it back to them. And then conciliation will be taken to a logical in whatever manner. Both the parties to appear, and thereafter, you see the process of entering into, you see this in this judgment also, the same judge is a party. Right?
Yes.
So we have had a lot of discussion on these
And
kind
even
of
this
aspects
judgment
of
was
the
referred to in my lord's judgment.
Must be, I don't remember.
Yes,
the
but it is
date.
there, no reference is there.
But on the face of the proceedings which we have seen over here, there is nothing. You see, the notices have been issued under section 18(1). Have you seen that heading? The notices were issued under section 18(1). Where is 18(2)? And then ultimately some amount was paid, fair enough. Some amount was still to be paid. Therefore, there has to be some proceeding drawn, and then the arbitrator will enter into the proceedings. And why this entering into the proceedings assumes importance? The reason is at the stage of conciliation, even a time-barred debt, otherwise not payable, can be paid, right? But when it comes to arbitration, the law of limitation applies fully. So these are the things, there are so many things involved in an arbitral proceedings. So that decision is not there at all. So there is a, what do you have to say, Mr. Rashid?
In pleading of the petitioner, it is not that they have not challenged in view of the section 18 minor, subsection 3 minor. They have only given ones regarding the constitution of the facilitation council minor, and the reply which has been filed before the.
You have seen the records. That is why you see yesterday also that specific point was drawn. Earlier also that point was drawn. The records are here before this court.
My submission.
If you want to, if you want them to include it by way of pleading, let them include it by way of pleading.
My submission is, my lord, no relief can be granted beyond the pleading, my lord. It is my submission, my lord. On that point, I am relying on judgment of the Supreme Court, my lord. That is Mrs. Akela Lalita versus Sri Konda Hamunta, my lord. ये पारा 15 and 16 live law AC 638 live law.
Yes, please.
And another, I also.
Para 15, 16, read it, please.
My lord. Issue number 2, 15. Coming to address the second issue, while the court is not effective to the petition of the respondent, grant permitted fact that absolutely no relief was ever sought by them for change of the surname of the child to that of first husband son of respondent. It is settled law that relief not found on pleading should not be granted. If a court consider or grant a relief for which no prayer or pleading was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice.
Are you aware that in connection with composition of an arbitral tribunal, what is the stage when that any objection can be taken?
They have filed reply मारो.
No, no.
And before.
आप मेरा बात नहीं सुन.
हम आपकी बात समझ रहे हैं कि जब इन्होंने इस पर ऑब्जेक्शन रेज नहीं किया,
इसकी बात ही नहीं कर रहे हैं. फैसिलिटेशन काउंसिल ने अगर कोई आर्बिट्रेशन किया है, what is the stage at which the objection to the constitution of the facilitation council can be taken?
After filing a reply.
No. Under section 16 of the Arbitration and Conciliation Act, when the facilitation council enters into arbitration, not prior to that. तो वो जो objection जो section 16 में वो ले सकते थे, वो तभी ना होता जब arbitral tribunal बनता.
लेकिन उनके यहाँ रिप्लाई थे, कोई एडमिट क्लेम को पार्टली एडमिट कर लिए ना कि क्लेम को एडमिट करके उन्होंने उस पर तो कोई
क्लेम कोई पार्टली एडमिट करेगा तो पूरा अलाउ हो जाएगा.
पार्टली एडमिट वो क्लेम पर नहीं है, उनका जो भी ऑब्जेक्शन रिलेटिंग टू इंटरेस्ट प्रिंसिपल अमाउंट दे हैव पेड. सो व्हेन ये पार्टी admit or not oppose the claim, principal claim, then he has no right to raise the further objection on the interest, my lord.
We do not know what is the remaining claim. How do we know what is the remaining?
So, my lord, it has not objected by the petitioner. My submission, my lord, your lordship has to. So, it should be recorded, my lord. And I am not saying that, but it is the prerogative of the court to take decision on the issue. But my submission is that in pleading, neither in lower court nor before this honorable high court, the petitioner has made any pleading regarding section 18 of the MSME Act.
What do you have to say to this?
I have already done that by filing a rejoinder on 18/11/24. Can you see that? They filed the counter affidavit, I filed the rejoinder, and in paragraph 7 I have stated so. That the petitioner states and submits that in the instant case the Facilitation Council, while passing the decree award on 23/3/2018 under the MSME Act, has not followed the mandate of laws laid down in section 18(2) and 18(3) of the MSME, and therefore the award dated so and so is annulled.
WPC number 3558 of 2020. Heard the learned counsel appearing on behalf of the parties. This the petition has been filed for the following relief. By the order dated 28/10/2024, the records of the case from Jharkhand Micro, Small and Medium Enterprises Facilitation Council, Goranda, Ranchi, was called for upon deposit of special messenger caused by the petitioner. The records have been received and the parties have gone through the records. When the case was taken up on 25/11/2024, the following order was drawn, which is quoted as the learned counsel for the petitioner, while assailing the impugned order, has submitted that the impugned order passed by MSME by the Facilitation Council is a nullity in the eyes of law, inasmuch as the required procedure in terms of Section 18 of the MSME Act has not been followed. The learned counsel has submitted that upon filing of petition by the private respondent before the Facilitation Council on (20/1/2017), notices were issued dated 6/2/2017 and thereafter on 3/4/2017. The said notices as found in the record are quoted as under. ये दोनों नोटिस को कोट करेंगे पेज 37 एंड 38 पर, इसको एम्बॉस कर देंगे, ठीक है। The learned counsel submits that a reply was filed by the petitioner on 4/8/2017. And during the pendency of the matter before the Facilitation Council, certain amount was paid by the petitioner to the private respondent amounting to rupees 22,07359 on 30/10/2017 and 5/2/2018.
On 5/3/18,
On 5/3/2018,
I was asked to clarify with regards to balance of rupees 288,140.
the petitioner was asked to clarify with regard to the remaining claim of the private respondent amounting to rupees 2,88,144. And the petitioner denied the liabilities on 6/3/2018. Where is that letter?
No, thereafter, straight away this order is being passed. The next
What did you
proceeding-
do to on 6/3/2018? Clarify the matter. It was also with regard to rest of the amount, and it was observed that failing which the council has no other option but to pass appropriate order in accordance with law. The notice dated 5/2/2018 is also enforced as such. Another notice dated 6/3/2018 was issued asking the petitioner to take a final stand in connection with the amount of rupees 2,88,144, failing which a decision will be taken on it. 6/3/2018 letter. The Learned Counsel submits that on 20/2/2018, the parties were present and the council directed to issue notice to take the final stand. 20/2/2018
My lords, if you sees the records में, records में page 78 एक बार देख लेते हैं.
78.
Records में page 78. 6/3/18 का ये है notice.
Page
NCR
78.
है.
हाँ, it's 78.
Page 78
Yes.
is the
6/3/2018.
yes. Yes.
Yes.
By this,
Yes. On 20/2/2018, the parties were heard and following order was passed. ये 20/2/2018 का impugned order से ले लेते हैं,
Yes,
right? उसमें है, हाँ.
Page 50.
Thereafter, on 23/3/2018, both the parties were present and were heard, and both the parties said that they have cleared their stand and they have nothing to say regarding this case. The hearing was completed and the case was kept for orders. And on 23/3/2018 itself, the award was passed. The Learned Counsel for the petitioner, while assailing the impugned award, has submitted that there is no failure report in connection with conciliation in terms of section 18 within bracket 2. And at no point of time the facilitation council took any decision to enter into arbitration either by itself or by any other agency. He submits that in absence of any arbitral proceedings in terms of the provisions of MSME Act read with the provisions of Arbitration and Conciliation Act 1996, the impugned award dated 23/3/2018 is a nullity in the eyes of law, and therefore the present writ petition is maintainable and the impugned award is said to be sufficient. The learned counsel has submitted that upon setting aside of the award dated 23/3/2018, the private party will not be rendered remediless. Still, the council can enter into arbitral proceedings after recording failure of conciliation, and appropriate award can be passed. He has relied upon the two judgments and the judgment passed by this court. He has relied upon the पिछला date में जो order है ना, two judgments and the judgment passed by this court in LPA number 505 of 2019.
Yes.
The learned counsel. Yes. Anything else you want to say?
No, those two Supreme Court judgments have been referred to.
Yes, which has been followed in LPA number 505 of 2019. The learned counsel appearing on behalf of the state has opposed the prayer and has submitted that the matter was required to be agitated in an appropriate petition under section 34 of the Arbitration and Conciliation Act 1996. He has relied upon a judgment passed by this court in LPA number 400 of 2022 and has submitted that the learned writ court in the same case had dismissed the writ petition as not maintainable with the liberty to challenge the award under section 34 of the Act of 1996. The LPA against the order of the writ court was dismissed, and it was observed that the court having jurisdiction to entertain the petition under section 34 of the Arbitration and Conciliation Act 1996 shall take a decision on the basis of materials on record and having regard to the object of the Act of 1996. He also submits that in the LPA number 400 of 2022, a plea was raised in connection with non-adherence to the provision of section 18 within bracket 2 of the Act of 1996. And it was also observed that the procedure by itself was a mixed question of fact and law. Correct? The learned counsel appearing on behalf of the private respondent, while opposing the prayer, has submitted that no such plea regarding non-adherence to the provision of section 18 within bracket 2 has been taken in the writ petition. Rather, in the writ petition, the plea taken is that the constitution of the council itself is illegal. He has he has referred to the judgment passed by Honorable Supreme Court reported in 2022 Live Law SC 638 within bracket Mrs. Akela Lalita versus Sri Unda Hanumant Rao and another, and has submitted that and has referred to paragraph 15 thereof, wherein the Honorable Supreme Court has refused to grant the relief which was not prayed for, and has observed that it is settled law that relief not found on pleading should not be granted. And if a court considers or grants a relief for which no prayer or pleading was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. That is all.
One thing, they are often matter the already the interest which is accrued during the pendency of the writ application as well as facilitation for settlement that also be taken is huge amount, and the with respect to deposit, statutory deposit, they have
The
not
Learned Council has
exercised.
also submitted that the statutory deposit of 75% has not been complied in the present case. Right?
Yes.
पूरा principal मिल गया था according to you? The entire principal amount was paid according to you? Yes or no?
The interest, some portion there is dispute
The
regarding
Learned
some
Council
portion.
has also submitted that only a portion of the amount claimed was paid and the remaining was unpaid, for which the appropriate award has been passed. That's it. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, in response, the counsel for the petitioner has referred to the rejoinder and has submitted that in the rejoinder it has been specifically stated that no order, no proceeding in terms of section 18.2 and 18.3 of the Act of 2006 has been followed and the award is a nullity. He has further submitted that the entire records are before this court and there is no question of any prejudice. The parties have already seen the records. That's it. After hearing the Learned Counsel for the parties and going through the records received and the records of the writ, and also of the writ records, this court finds that upon filing a petition by the respondent, a notice under section 18 within bracket 1 of the MSME Act was issued dated 6/2/2017. And thereafter, another notice in continuation was issued, which was dated 3/4/2017. In response to the notice filed under section 18.1, the petitioner filed reply and during the pendency of the proceedings, certain amount was paid by the petitioner as is apparent from. We need not give the amount, we have already given. We have already mentioned.
Yes,
Certain amount was paid by the petitioner as is apparent from the impugned award itself. a notice dated 12/8/2017 was issued to the petitioner, wherein it was observed that it was in the own interest of the petitioner to settle the dues mutually, failing which penalty provisions under MSME Act is on compounding basis. And the next date schedule of the meeting was 4/9/2017. 12/8/17 का नोटिस को एम्बॉस करना है 65 पेज 65. And it was only thereafter certain amount was paid by the petitioner. With regard to the remaining amount, certain clarification was sought for from the petitioner. White notice dated 5/2/2018 indicating that if the petitioner fails to give clarification, the council will have no option but to proceed in accordance with law. And thereafter, on 6/3/2018, again an opportunity was given to the petitioner to take the final stand. And it was mentioned that if the petitioner does not appear on 16/3/2018, the decision will be taken on merits. On (20/2/2018), thereafter the meeting was held on 20/2/2018, wherein following order was passed, इसको quote करना है from the impugned order, and ultimately on 23/3/2018, both the parties were heard and they cleared their stand that they had nothing else to say. And on the same day, the impugned award has been passed. This court finds that the records does not reflect, on the face of the record, no proceeding, there is no failure report in connection with the conciliation proceedings in terms of section 18 within bracket 2 of the Act of 2006, MSME Act of 2006. Further, the conciliation, the proceeding on 23/3/2018 reflects that on the same day itself, both the parties had cleared their stand that they had nothing else to say, and on the same day the impugned award has been passed. On the face of the proceedings, this court finds that there was no decision to take up the matter for arbitration, and the award has been passed without entering into arbitration at all. On the face of the impugned order, this court finds that the proceeding prescribed under the MSME Act has been given a complete go-by, and without entering into arbitral proceeding, the award has been passed. In such circumstances, the impugned award cannot be said to be an arbitral award at all in the eyes of law, which can be subject matter of challenge under section 34 of the Arbitration and Conciliation Act 1996. The impugned award is expressly a nullity in the eyes of law, and since the impugned award is not an award in the eyes of law, therefore there is no question of deposit of 75% as objected to by the learned counsel for the respondent. So far as the plea of the respondent that no stand has been taken in the petition in connection with section 18 within bracket 2 is concerned, this court finds that upon receipt of the records, this court finds that such stand has been taken by the petitioner in the rejoinder. The paragraphs are quoted as under, and the counsel for the private respondent at no point of time sought, has not responded to the rejoinder and has not even prayed for any time to respond to the rejoinder. This court also finds that since the entire records have been received and the parties have gone through the records and have referred to the records at the time of argument, no prejudice has been caused to the either parties, and the pronouncement in this judgment is and the impugned award especially reveals that the MSME Council either itself or has not taken any decision to enter into arbitration. The decision to enter into arbitration is followed by subsequent procedure as per the provisions of the Arbitration and Conciliation Act 1996. The judgment passed by this court in LPA number 400 of 2022 is clearly distinguishable on facts in view of the nature of proceedings narrated in the order itself, wherein the respondent number 2 of the said case had put the appellant to notice that if it fails to make any proposal, it will be presumed that the conciliation exercise has failed. And thereafter, the respondent number 2 had communicated to the appellant of the state case through another letter that it intended to communicate the failure report to the Facilitation Council. And these materials were placed before the Facilitation Council. In the aforesaid factual background, this court in the Honorable Division Bench in paragraph कहाँ है क्वेश्चन ऑफ फैक्ट मिक्स्ड क्वेश्चन ऑफ फैक्ट
Mixed question of fact.
has in paragraph 22 of the judgment itself formed a prima facie opinion that whether or not the procedure of subsection 2 of section 18 of MSME Act has been followed by the Facilitation Council was a mixed question of fact and law. And in paragraph 30 of the judgment, the Honorable Court observed that the claims on adherence or non-adherence of the provision of section 18 within bracket 2 of the Facilitation Council can be decided in section 34, where the parties may support their rival claims with reference to the materials on record, and such an exercise could not be undertaken in a writ proceedings. Since this, the state judgment is distinguishable and has also been considered by this court in LPA number 505 of 2019. Referred to.
Yes. It is at para.
That's right.
Page 5.
H.
H. H type para
Yes.
H.
Uh, this court finds that on the face of the impugned award, which clearly reveals that the stand was taken on the stand of respective parties was clarified only on 23/3/2018, and the award was passed on the same day, reflects that at no point of time there the Facilitation Council took a decision to enter into arbitration, much less entering into arbitration and passing it on. The case is squarely covered by the judgment passed by the Honorable Supreme Court in the case of Jharkhand Urja Vikas Nigam Limited versus State of Rajasthan and others, reported in 2021, SCC Online 1257, and Gujarat State Civil Supplies Corporation versus Mahakali Food Private Limited, and another reported in 2023 within bracket code 6 SCC 401. This court is also of the view that so far as the constitution of MSME Council is concerned, the objection to the constitution of the arbitration tribunal, if at all, was required to be taken at the stage of section 16 only after the arbitral tribunal would have entered into reference. But there was no such occasion, and ultimately the award has been passed without entering into reference in terms of the provisions of as required under the provisions of MSME Act 2006 read with Arbitration and Conciliation Act. Consequently, the impugned order is hereby set aside, being a nullity. However, the petitioner as well as the private respondent are directed to appear before the Facilitation Council. I'll give a date, right? At 11 a.m. Upon their appearance, the Facilitation Council shall proceed and if ultimately the matter is not settled, this shall proceed step by step under section 18 of the Act of 2006 in accordance with law, and in the light of the judgments which has been passed by the Honorable Supreme Court. There will be changes in the order. It is just an open court dictation, but this is what it is.
Paragraphs were 7 and 8 of the judgment.
I just told that. Is there any interim order?
There was an interim.
Interim order stands vacated. अब क्या ही बचा ही?
हाँ नहीं interim order
Pending IA closed.
Yes.
The office is directed to send the records to the Facilitation Council. इसको जरा ठीक से रख दीजिए
सीरियल 4 वाला
हाँ
नेक्स्ट वीक में 500 रुपया काटते हैं
क्या हो रहा है सीरियल 4
मेंशन किया था ना
हाँ
वो नहीं है
क्या करना
नेक्स्ट वीक कर दिया 500 रुपया काटते हैं
क्या चीज़ कब के लिए करते हैं बताइए
नेक्स्ट वीक में किसी यही वेडनेसडे
just let me finish
4 तारीख
although the matter was placed before this court today at the request of the counsel for the petitioner, but the petitioner is seeking adjournment on ground of personal difficulty of the arguing counsel. Mr. Piyush Krishna Chaudhary, he submits that on the next day, no adjournment will be sought. At his request, closed this case on the 4th of December 2024 with a clear stipulation. Will you come back?
Yes, I'll come.
No problem. You have informed the other side?
I'll inform. Now I'll be informed.
कोई और भी मैटर से बना के रखेंगे
The matter is being heard possible फिक्स मैटर
एक ही मैटर है ना,
नहीं
दो मैटर
5 मैटर
फिक्स है, सवा 2 बजे
तब तो
ठीक है, तब तो हो जाएगा।
हो जाएगा